Lordship, item 9, Lordship. I need 1 week time to file resign, Lordship.
Why?
Lordship,
What is the PIL about? Can you tell us?
Lordship,
What is the PIL about? What is the subject matter of the
Lordship,
PIL?
and enforcing some powers of the Autonomous Council of Karbi Anglong, Lordship, by the state government, Lordship.
The counsel for the petitioner pays for time. The other side has no objection. List up to 6 weeks.
Lordship.
Your Lordship, I beg to mention item number 29. Your Lordship may kindly pass over the matter for days of accommodation. My senior is facing some personal difficulty.
29. A request is made to adjourn the matter on behalf of the appellants. The other side, appellant kar dijiye. As no objection, list up to 4 weeks.
Please, your lordships. I'm praying for listing of one newly filed read appeal next week on Friday, my lords.
List on Friday.
Like,
Daily list for orders item 1.
May the Lordship. As per last order, my lord, your Lordship, please to ask me to provide some earlier case order. my lord.
Yes. There's a categorical statement of the respondents that road section in Assam has been completed.
Yes, Lordship.
Then for Meghalaya, you have to approach the Meghalaya High Court.
Well, the grievance is there because for the people of Assam, those who are living in Barak Valley, my lord, but the grievance still exists because
What section, Mr. Prakash, what section of the road?
mere completion of the part of the some portion of the road, my lord.
We understand, but if there is a incomplete road in another state,
Your
which
Lordship,
earlier was, of course, under the supervision of the Guwahati High Court, no longer now.
my lord, therefore I placed your Lordship this order, my lord.
What order? Let's see.
Last occasion, the second round of litigation, PIL, my lord, on the same issue, my lord. This honorable court was pleased to issue notice upon the respondents in respect of Meghalaya state, my lord. This is the order, my lord.
So part of cause of action, there are distinct causes of action. Part of the road in Assam, part of the road in Meghalaya.
Yes.
Assam part is completed. So no part of cause of action survives now.
No, my lord, for the pain and sufferings of the people of Assam, my lord.
No,
till
like-
till now,
So supposing now the Assam people of Assam
Yes.
want to get down at Begusarai. Okay. The train Rajdhani goes through that route, it doesn't stop. Can we give that direction?
That is
Then that is same thing.
not
Same thing.
Not same, my lord, because my lord, the connectivity, the sufferings every year during monsoon, my lord, every year it's a huge lot of suffering, my lord. That
That
cannot
is
be-
the vagary of nature. What can we do?
Yes, that is why, my lord, this alternative for the construction of this alternative road, the survey has been
Tomorrow
done.
you will ask the respondents to construct a 100 feet tall flyover in the territory of Meghalaya.
No,
Is
no,
it
no.
possible?
It is
Then-
not like that. It is not like that, my lord. It is, we are not asking. They have the respondents, state respondents, they have done the survey. They have submitted proposal and the fund to some extent has been sanctioned also, my lord.
By whom?
Thereafter,
By
by
whom?
central government, my lord.
All
NCD,
right.
it's a central government. my lord.
Yes.
Thereafter, my lord, the construction,
Hmm.
some portion has been done in respect of Assam, my lord. In some portion in Meghalaya also done, my lord. But the entire completion has has not been done. But the work is started.
We really appreciate your concern, but merely because you are concerned about the plight of some people in Assam who are aggrieved by non-completion of a road in Meghalaya, we can't assume jurisdiction.
No, my lord,
We leave you at liberty. Shillong is just 2 hours away. E-filing kariye. Argue the matter there. Disposed of.
my lord,
What is the big deal now?
my lord,
File a petition. Use the e-filing mode. Argue from here.
my lord, observation may be made from your lordship, my lord, for completion of the work is a need of the time, my lord.
We don't have any response about the part of the road in Meghalaya. We don't have any material. And even if there is some material, we are nobody to comment on that.
But the road is under construction by the.
That is right. So
Central
many
agency.
thousands of roads in the country are under construction. Can we assume jurisdiction? Tomorrow you will come out and say, many people of Assam are settled in Bihar, but there is no connecting road. Please direct that a road should be constructed.
But your
That
lordship
can be done.
observation will help us, man. Your lordship observation.
What is the material for this court to make that observation?
Because, my lord, yes, lordship is there, page number 75.
You
is the
can
matter.
always pray for a liberty to approach the Meghalaya High Court. That's the better way.
My lord, page 75, your lordship is just last paragraph, my lord. That may be quoted in the order, my lord. That will be helpful for us. my lord.
What is it? Plain away.
Even for approaching the Meghalaya High Court, it will be helpful for, my lord. The last paragraph of the page 75, my lord.
Land Council, Mr. Purkas, while responding to the query made by this court on the last date of hearing, candidly concedes that the part of the road which now remains to be completed is falling within the state of Meghalaya. However, is fervent contention by referring to a communication dated
7 March 2000.
7 March 2018 is that the executing agency has admittedly, not completed the said part of the road which connects Barak Valley of Assam to Meghalaya has not been completed. Under these circumstances, he craves liberty to withdraw this writ petition seeking leave, that the petitioner would be better advised to approach the appropriate High Court for ventilating the remaining grievances. In view of the statement so made, the instant PIL is closed with the liberty paid for.
Obliged.
Item number 2.
Secondary education,
Secondary.
ma'am. Who is there? Mr. Mazumdar, pass over.
My
Do you have any information what happened to the appeal?
lord, the appeal has not been, my lord, considered, still pending. My lord, can.
It's possible.
Obliged.
Item number 3 to 5.
May I please, your lordship? Lordship, as per office note dated 24
Part 4, 5 and 6 not served.
not served.
Service has not been effected on the response numbers 4, 5 and 6. Thus, fresh steps be taken. Steps be taken again within next 7 days whereafter. Notice be issued to such respondents. Rule is made returnable in 4 weeks.
Deeply obliged.
Lordship, I would pray another matter may be tagged with this series, Lordship.
Why?
Same issue, Lordship.
On this submission of land council, Mr. Your good name?
C. Sharma, Lordship.
C. Sharma, what is the petition number?
WPC 44.
File of so and so involving identical issues shall also be tagged with these 3 petitions.
Obliged, Lordship.
And all cases shall be, all similar cases shall be listed together.
Obliged, Lordship.
Item number 6.
Similar matter is pending, lordship, before
Hmm.
lordship, and your lordship was pleased to issue notice. It's similar.
Similar matter, all right. Issue notice to the respondents. Standing council, mark the names of all, appear for the respective departments.
I'm appealing for higher education.
uh, Steps for service upon the respondent principal, Maibong, you will be appearing? No. Steps for service upon the respondent number 5 be taken within 3 days, whereafter process be issued Who will be appearing for the Autonomous Council? Number 2. Number 2 and number 4. Dima Asao. Mr. C. Sharma appears for the response numbers 2. 2 and 4. 2 and 4. Okay. Connect and list with so and so.
Item number 7.
Lordship, we are filing an affidavit in reply during the course of the day, Lordship. Yesterday only we have got it. So
What is the controversy, Mr. Kalita?
controversy, because Lordship, it was
Petrol pump.
petrol pump, Lordship.
Okay. The petrol pump is functional. It's operating.
It's functioning.
It
right?
is functional, my lord. We are by adhering the guidelines by issued by the central police.
That you state when the matter is taken upon
No,
merits.
it is in the records also, my lord.
But should we not grant him time?
They have not, company has not filed an affidavit till date.
But it is in a record, my lord.
Company who appears for the oil company?
Myself.
You are for the oil company. You are not filing
He
the,
hasn't filed an
affidavit.
as yet, Lordship.
Kindly see, my lord, page, my lord.
make a statement that you don't want to file it. Then we'll close your opportunity.
My lord,
They are the main party, Lordship. They haven't filed.
Yes.
Affidavit.
some time may be granted, my
Uh,
lord.
Then council, Mr. Your good name, please.
As Botaku, my lord.
As Botakur appearing for
For
the
the. For as per number 4, my lord, BPCL, my lord.
respond number 4. Praise for and is granted. Further opportunity of 4 weeks to file affidavit on behalf of such a respondent. Full stop. After the respondent, after the affidavit of the respondent number 4 has been received, the petitioner would be at liberty to file an affidavit in reply. List after 6 weeks.
Published.
Item number 8.
Please, Your Lordship, we need some more time to file our reply. And the other respondents have not filed their affidavit.
Who has not filed the
1, 2, 3, 4, and 6.
1, 2, 3, 4, and 6? Madam,
Lordship, I am appearing for 6, my lord.
Union of India,
No, Lordship. Union has already filed their affidavit.
Union has filed affidavit.
Filed.
Madam, how are you saying 1, 2? 1 has already filed the affidavit.
Because on the last occasion, Lordship.
The number 4 has filed the affidavit.
Yes, my lord.
But what about 1, 2, 3?
1, 2, 3, I am not appearing, my lord. I am only for affidavit number 6, my lord. 6 affidavit is not required.
6 affidavit is not required?
It's a Women and Child Development Government of Assam.
They don't normally. Number 5, there is no 6.
6, I am appearing, my lord. 6, I am.
There is no respondent 6. Department of Women and Child Development is respondent number 5.
In my petition, my lord, is affidavit number 6, my lord.
Have you added a respondent? 1 is Union of India. Number 2 is MO, Ministry of External Affairs. Number 3, Kara. Number 4, State. And number 5, Department of Women and Child Development.
In my petition, Lordship.
Anyhow, doesn't matter. Oh, 6. Probably you are confused. This poor God is 6. Are you mentioning that?
My lord, they have not did not mention this, but only serial number 6.
Okay, very well. Yes, madam. Reply of Union of India, affidavit of Union of India. Already been filed. When?
I don't 27/6.
No. 27/6 is R4. You have filed, do you make a statement? There must be some defect in council MS. Devi, associate to Mr. RKD Chaudhary, states that
Respondent 4.
affidavit has already been filed on behalf of the respondent numbers 1 and 2 on 27th June. They registered to check and tag. Yes, affidavit is RKD Chaudhary has filed affidavit
Yes, sir.
on behalf of respondent 4.
Respondent number 4, Lord.
Registrar General Directorate of Census Operations, Assam. We need affidavit of 1 and 2.
1 and 2. Oh, 1 and 2. Yeah, 1. They filed only for 4 documents.
So do you want to file or not?
Lordship will file.
Associate to Mr. R.K.D. Chaudhary praised for and is granted 4 weeks time to file affidavit in opposition on behalf of such respondents. List up to 4 weeks.
Item number 10,
May it please, Lord.
Yes.
The only issue with this, this appeal is, my lord, whether the FCI as a service receiver could, my lord, under the terms of the contract, shift the liability of paying GST to this, my lord, service pay.
We'll have to admit it. No one appears. That's the problem. Admit issue notice. Steps for service be taken within 3 days, whereafter process be issued to the respondent.
My lord, we have taken earlier, my lord.
That was pre-admission. Now it is after admission
No.
once service has to be. That guy is incorrigible.
item number 11,
This one, no one has appeared on behalf of the respondent after service of show cause notice. Full stop. The learned legal aid counsel withdrew her instructions, whereafter comma notice was again issued to such respondent, but despite service comma no one appears on his behalf. Thus, the writ appeal is admitted. Admit issue notice. Yes.
But they file an affidavit, my lord. I'll take 2 weeks time to file a reply, my lord.
And counsel for the appellant praised for and is granted. Affidavit must have been filed in the writ petition.
In
Actually,
fact, Lordship, as per my lord direction, Lordship, we have filed this affidavit. Lordship would ask me whether the case of the petitioner could be considered as per clause 15 of the Omnibus
15.
2015.
Okay.
We have stated, my lord, in page 84,
Hmm.
paragraph 4. Lordship, may kindly have a look.
What have you stated? Please
Uh,
state, read.
Since there is no vacancy
No vacancy.
in other
Okay.
department also.
And
so we
counsel
could
for
not
the
consider.
appellant praised for and is granted 4 weeks time to file affidavit in reply.
I'm obliged. my lord.
Deeply obliged, my lord.
Rest up to 4 weeks.
item number 12,
We are yet to serve the memo of appeal, my lord.
Memo of appeal, gentlemen,
It's a 7/6 to.
counsel for the appellant. Oh, what is, nothing is required. Writ petition filed after 21 years. All right, argue.
Lordship, my senior is in all legs, can't meet maybe pass over
Pass.
for the time being.
Pass. The writ was filed after 21 years.
item number 13,
Medical students that are, well, they have served copies today, but I would also pray, well, let National Medical Commission, they should also file affidavit whether it can be permitted or not. If they say no, my lord, I think.
Then you would- NMC, who is representing the National Medical Commission.
Lordship. DK Vaidya appears, Lordship. DK Vaidya.
DK Bedya.
We'll inform you.
And
Please inform him, call him once so that we can instruct him.
So
File
that-
an affidavit.
Because they are the authority now. If they take a call, my lord, if they say no, my lord, we will have difficult problem.
Let them come forth.
item number 14,
Your Lordship, Lordship, this case is led by senior counsel K. N. Chaudhary, Lordship. He is on lax, Lordship. Pass over for the time being.
Pass.
Obliged.
Where is Ms. Chaudhary was supposed to respond in this case? Ms. Chaudhary was to inform the court what has happened on his application.
item number 15,
Mr. Nath is still not attending the court. Hmm?
He's suffering from my lord eye infection.
What has happened? Did Mr. Kumar visit the areas?
Your lordship, not yet. We have not yet visited the areas. We're
Uh,
just waiting for the reports from the government side.
No, he was supposed to make an
Yes.
inspection.
Yes, lordship, but
He requested the court that permission.
yes,
He could not do it.
yes, not at the point. Yeah.
Land Council, MSPV Thanyu,
Yes, lordship.
states that senior advocate Mr. B.D. Kumar, within bracket amicus curiae, could not visit the shelter areas because of some preoccupations. Some more time is needed to do the needful. List, re-notify.
And lordship, they also have to give some detailed reports on the other 8 districts. For the rehabilitation of this.
What about the full-time secretaries? The detailed reports of the full-time secretaries in terms of the order dated so and so have not been received. The registry to ensure that copy of the order dated 27/6/2023 is communicated to the member secretary, Assam State Legal Service Authority, for ensuring compliance of the directions given therein. Re-notify on 9th October. If find out whether this order was communicated or not. It doesn't have any noting. Seems it was not.
Item number 16 to 28.
Ration card, fair price shop,
My lord,
who is appearing for the respondents.
AG was to appear, my lord.
Let him complete his part. We'll
Okay,
complete his part.
you argue your case. AG will join the
My
thing
lord.
later.
Well, may I start? ma'am?
Yes, yes, definitely.
My lord, this is a matter wherein, my lord, 14 FI shop owners who have been running the FI shop on license granted to them and renewed for 20 to 25 years. Suddenly, my lord, their licenses were renewed up to 31st of March 2022. And thereafter, when they have gone for further
Renewal.
further renewal, at that point of time, my lord, their licenses were neither renewed nor any action has been taken. So there, my lord, we have made a representation to the additional director, my lord, and the additional director has not disposed of our application, my lord, and suddenly 2 of the notifications have been issued. If a lordship comes to page 84, my lord,
84.
page 84, my lord. This is from the Manas Associate Director to the Principal Secretary and other. So this is the input order, my lord. May I read, my lord?
Yes, yes.
With reference to the subject cited above, I have the honor to inform you that in view of the installation of EPOS devices in the paper shops and implementation of One Nation, One Ration Card scheme in the state, and as the decision of the state cabinet, it is necessary to tag the ration card holders of the paper shop having 50 or less than 50 numbers of consumers reflected with the nearest, attached with the nearest paper shops having more than 50 ration cards. My lord, prior
So
thereto-
those who were having less than 50 consumers,
yes, ma'am.
they were virtually merged in the fair price shop
Yes,
where there were more than 50 consumers.
yes, no, that is the, that government has taken a decision.
Whether the cabinet decision is on record?
Cabinet decision, my lord, if a lordship comes to page 131,
Malad, this is at the top, Milord, your lordship will find circulated during cabinet meeting. That means if it is circulated only, but then that was not finally taken decision, and that decision is not executed over here, Milord.
Let us read what the decision is. Cabinet directed that
Yes.
the following modifications be effected to the proposal. There is a discussion. The minutes read. After threadbare discussion, the cabinet approved the proposal of so and so.
Now, my lord, that your lordship will find circulated during cabinet meeting. Milord, there is a rule. I will draw
Even
attention-
despite circulation, the
No, my lord.
matters can very well be decided by circulation. There is no
No,
difficulty.
my lord, there is a procedure, my lord. If a lordship comes to, I have already submitted, my lord, the Assam Rules of Executive Business 1968. If a lordship comes to page 4, my lord.
Have you provided a copy of the rules?
So, yeah, it is.
Copy dena bhi. The rules dena.
Assam Rules of Executive Business 1968.
Yes.
One word, okay. If a lordship comes to page 4, at the end, my lord, towards the end,
Yes.
Rule 17, my lord, when it has been decided to bring a case before the cabinet, the department in which the case belongs to, unless the chief minister otherwise directs, prepare the memorandum indicating with sufficient precision on the salient facts of the case and the points for decision. Such memorandum and such other papers are necessary to enable the case to be disposed of and shall be circulated to the ministers. Copies of the memorandums and other papers shall at the same time be sent to the governor. Miller, that is to start with, Miller. If your lordship comes to Rule 19, Miller,
Come to 19(3).
yes,
Yes.
except with the permission of the chief minister, no case shall be placed on the agenda of the meeting unless papers relating thereto have been circulated is required.
So
by-
all right, now there is a power of the chief minister
No, my lord,
permit circulation even contrary to the provisions of Rule 17.
no, my lord, my contention is not that chief minister is not having the power. What chief minister is having the power. When we were arguing this case before the learned single judge, Miller, we were appealing that at least the record should be brought and the court should be satisfied whether the procedure has been followed or not. And your lordship, if your lordship comes to clause 6,
Yes.
clause 19, clause 6, Miller, the secretary to the cabinet shall attend the meeting of the cabinet and shall prepare a record of the decision. He shall forward a copy of such record after approval of the chief minister or by any other minister presiding to the chief minister and other cabinet ministers and the governors. Miller. So that is the procedure laid down by this particular rule, Miller. And we were making appeal before the learned single judge that at least the record may be called and it may be verified. If it is procedure is all right, then we have got nothing to say on that.
Things are there in the affidavit, sir. Affidavit is there. Let us read the affidavit. You have made a assertion in the government in your petition. Let us see your government.
Yes.
Yes. So your only argument is that this procedure was not followed. That is the only argument.
No, Mala, other aspects are also there.
So then just now you said that if the procedure has been followed, we have nothing to say.
No, procedure, if the procedure is done, Milord, then in that case, the cabinet decision is in the order.
So forget
But-
about the
but then
procedure
cabinet
part.
decision, but then
Come
cabinet
to
decision-
substance, forget about these technical arguments.
No, but yes, Milord.
They are basically trying to comply with the food security issues.
No, my lord, then in that case, Milord, the main statute that governs the entire affairs, Milord, it is the National Food Security Act, Milord. If your lordship allows me to read especially section 12 of the act. Milord.
Yes, please read.
reforms in targeted public distribution system.
Hmm.
The central and the state government shall endeavor to progressively undertake necessary reforms in the targeted public distribution system in consonance with the role envisaged for them. The reform shall inter alia include: the first condition is doorstep delivery of food grains to the targeted public distribution system outlets. Doorstep delivery, Milan. But in that particular case, Milan, what they have done, assuming that the above 50 and below 50 million, so they have made a discrimination and that discrimination is not reasonable in that case. My contention is, Milan, this is the mandate of the law that the food grains are to be provided at doorstep. Now, Milan, after this implementation of that particular policy, Milan, what happens? The consumers had to move about 7 kilometers, 8 kilometers, 9 kilometers to get their ration. Another important point is, Milan, these
Are any of the consumers before us? Are any of the consumers before us raising this grievance that they have been inconvenienced by this decision?
no, we are arguing.
Then ultimately it is the consumer who is to face the difficulty.
No, my lord, if we say in that, my lord, all the citizens.
This is all meant for the benefit of the consumer.
Yes,
Targeted deliveries, public distribution system
yes.
is for the benefit of the consumers. So the end user, being the consumer, has no grievance.
No, my lord, one thing is there. Probably your lordship knows about the literacy, legal literacy of our total population of India, my lord. If we consider in that way, that you are a citizen, whether you are literate or illiterate, you must follow the law. If you do not follow,
Presumption that everyone is supposed to know the law.
my lord, I think the proposition is totally different, my lord. Socio-economic justice,
Yes,
that indicates socio-economic justice is the responsibility of the state.
yes, yes.
They may not be aware of, but then at least whether they are aware or not, it is the responsibility of the welfare state to provide them whatever is mandated by the law itself, Milan. And another important thing is this is women empowerment, Milan. Now the household concept has been changed. And in this particular act, the woman is the head of the family, Milan, and she is the ration card holder, Milan. We'll have to see about the difficulties that are faced by the consumers for whom we are providing these facilities, Milan. From that angle, Milan, my contention is that if that woman who is a householder or who is the ration card holder, if she has to move about 7 kilometers, 9 kilometers.
Counsel,
if instances-
You are living in a totally imaginary world. In Rajasthan, there were times when the women of the household had to walk 20 kilometers for getting one pitcher of water. So this is almost a luxury. If you 7 kilometers, nothing. Now the means of transportation are there. The
My-
PMGCY roads are there.
Milan, in that case, Milan.
We are again and again asking, sir, which of the consumers have come forward raising this grievance that this has caused them problem?
No, if that is
This is
so, then.
the entire role of the fair price shop dealers is hardly anything to do with it. This is for the matter of convenience of distribution that this system has been set up. If the consumers say that we are fine with the new system, you are no one.
No.
Do you have a right to operate a fair price shop? Fundamental right. Tell us, please. You have
No,
invoked the writ jurisdiction.
No, my contention is, Milan,
Yes.
illiterate citizens, as they are not aware of their fundamental right under Article 2012.
Sir, we are talking of illiterate citizens. We'll tell you practically, the fact is that everyone in the family has a BPL card. Everyone has got a ration card. They are being benefited by the welfare schemes of the government, right, left and center. There is no one deprived now. Manrega, everyone gets registered.
No, but then the mode of supplying and the mode of service, Milan, that is to be.
I'm telling you, who is aggrieved by this distribution system, sir? Tell us. Not a single individual has come forth.
No,
Any
Milan,
representation, please
No.
tell us.
in
Any
that case,
representation
Milan,
by the consumers.
in that case, Milan, the laws which are in operation, Milan,
Yes.
if all the laws are to be ignored, I have got nothing to say. Milan.
Ignored, not a question
No,
of
no,
ignored. sir.
yes, I'm submitting the rules, Milan.
Yes, please.
Rules formulated under
Tell
the
us.
particular act, Milan.
Yes.
If your lordship comes to the targeted public distribution system order 2015, my lord. That is along with this particular act, my lord.
National Food Security Act,
Yes, my lord.
let's see.
Public distribution, okay.
Targeted. Can you tell us the page number, please?
Yes.
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 Please read what are you reading, sir?
Yes, sir. This is Milan Targeted Public Distribution System Control Order 2015, Milan.
Yes.
Your lordship got it.
Mhm.
If your lordship comes to page 20 of that and rule 9.
Yes.
May I read, Milan?
Hmm.
Licensing and regulation of pepper shops. The state government shall issue an order under section 3 of the act, but not inconsistent with this order for regulating the sale and distribution of the essential commodities. The license to the pepper shop owners shall be issued under the said order, and the order issued by the state government shall be notified and displayed in the web portal. The designated authority appointed by the state government shall issue the licenses to the pepper shop owners. The state government shall accord preference to the public institution or public bodies such as panchayats, self-help groups, cooperative societies in licensing the pepper shops and manage the pepper shops by women.
Management of fair price shop.
Yes, management of the shop by the women in their collectivity. The license to the pepper shop owners shall be issued keeping in view
Viability.
viability of the pepper shop.
Yes.
Next clause, Miller. The state government shall ensure that the number of ration card holders attached to a fair price shop are reasonable.
Yes.
Then the fair price shop is so located that the government or that the consumer or the ration card holder doesn't have to face difficulty to reach the fair price shop, and that proper coverage is ensured in hilly, desert, tribal, and such other areas for difficult to access.
Yes.
So that is there because I represent the.
You will
pepper
have to
shop owners.
demonstrate in each case
Yes.
that by this change, what is the change in the topography? How far the shop has been removed? You will have to demonstrate that then.
that
Each
continuous
individual
inform-
case will have to be considered. That this has resulted into a disadvantage to the consumers.
Second point, Miller.
Yes, please.
The state government shall fix an amount as a fair price shop owner's margin, which shall be periodically reviewed and ensuring sustained validity of the fair price shop owners. The state government shall put in place a mechanism to ensure the release of fair price shop owners margin without any delay. The state government shall allow sale of commodities other than the food grains distributed under the targeted public distribution system at the fair price shop to improve the viability of the fair price shops operations. That means not only the. essential
Any
commodities,
other
but
commodity can be sold.
Yes, sir.
Yes.
So that is also a law, Milan. Then another point is.
What is the violation of this law, sir? Tell us.
No.
What is the violation in these impugned minutes?
No, Milan, that is doorstep. The facilities are provided at the doorstep.
But
And also the fair
tell
price-
us, by
fair
having a fair price shop of less than 50 ration card holders, does that ensure doorstep delivery?
But the paper shop are to be, the number of holders of such a test are to be reasonable. Well, what is the
Reasonable. So
reasonability?
less than 50 is not a viable option. That is what the state feels. What is wrong in it?
No, they
Less
will-
than
they will have
50
to
can't be
reasonable.
viable. Then that there is a presumption, there is a suspicion that the dealer may indulge in unfair practices because 50 consumers would not give him the margin to sustain. That is what the observation is.
No, my point is, Milord, can the state take an arbitrary decision that what we decide something and this will follow?
So
That
policy-
cannot be the law, Milord.
Policy decision has been taken, sir.
No, policy
that
decision, no,
they-
policy decision,
the-
there should be some
sir,
balance between the
the
policy and the.
Rule
state
6,
decision.
Rule 6 says number of ration card holders are reasonable. Now they have taken 50 as a yardstick. What is unreasonable about it?
The one thing is, Milord, they have made in that particular policy the geographical discrimination. Say, for example, in that particular impugn order, Milord, they have excluded the two Karbi Anglong districts and also Dima Hasao.
Hmm.
So what is the basis for that? Because consumer is a consumer all over India, because once it's a national ration card in a that is applicable to the nation.
Yes.
So what is the reason of making a discrimination that the people of Karbi Anglong, two districts and also Dima Hasao is totally separate from the plains districts? They will have to reasonify that word, Miller.
You yourself stated the difference, plains districts and the hill districts. That is what mentioned in the rules, sir. Looking to the terrains. That is what the requirement of the rule is. They have taken care of everything. It so seems. Now tell us what is the, what is wrong in the impugn judgment?
Satisfied with that? I have.
Let
nothing,
us,
Miller. I will
let
not
us come to
argue.
the impugn judgment. What is your argument and how it has been dealt with? Come to the impugn judgment, please. Show us what is wrong in the judgment, please. How have your arguments been dealt? Please let us know.
Miller, if your lordship comes to page 327.
Paragraph.
I'll- 327. It is paragraph 26, Miller.
Yes, please.
May I read, Miller?
Yes, sure.
On the basis of the above precludes, let this court therefore take into consideration the facts involved in the instant case. All the writ petitioners herein claim that they have been issued licenses in terms of order 1982 for supply of notified articles to the area of operation specifically mentioned in their license. The said licenses upon being issued initially have been renewed from time to time and yearly, time to time on yearly basis up to 31st March 2022. And thereupon, in view of the decision taken by the government of Assam to tag those fair price shops having 50 or less than 50 ration cards to the nearby fair price shops, their licenses have not been extended and they have also not been allotted food grains for distribution. And as such, the above writ petitions have been filed. The petitioners have challenged the policy decision of the respondent state government to close down those fair price shops having 50 or less than 50 ration cards, to tag those ration cards to the nearby shops on the following grounds. Number A, Milan, the policy decision of the state government has caused serious prejudice to the petitioners who have been sustaining their livelihood by running those fair price shops after obtaining license from the competent authority. The said policy of the government has no reasonable nexus with the object sought to be achieved. In Adma says, the decision of the state government has nothing to do with the one nation, one ration card policy, which was directed to be implemented all over India by the Supreme Court in its judgment order dated 29/6/21 in Bandhwa Mukti Morcha Milan. It is mentioned earlier. Then it is also the case of the petitioners that if it is on account of the point of sale device for which the state government has resorted to the policy, then in terms of clause C of section 7(6) of the rule 7(6) of the assistance rules in 2015, the petitioners are ready and willing to purchase and install and maintain their EPOs. Thus it violates devices, and as such, the said region cannot be a region for the purpose of depriving the petitioners in their livelihood. Then it is for the case of the petitioners that the authorities during the validity of the said licenses cannot by means of policy decision deprive the petitioners from their legitimate right to run their proper shops by contravening their statutory right provided under order of 1982 and the licenses issued on the basis thereon. In other words, the petitioners have legitimate expectation that these licenses would be renewed from time to time if there is no violation of the provisions of Act of 1955 or the orders issued therein under the terms of the license. License is granted and with the condition that if any of the provisions of license is
That is
violated.
one of the grounds. But whether or not to extend, to get the license extended, it can't be a fundamental right. It can't even be a civil right. It's only an expectation. But if there's a policy decision not to extend, Bihar, out of the blue, they stopped sale of liquor. Whether the license holders can claim, no, we have a right to get the licenses extended. Can't be done, sir. Poppy straw in Rajasthan. It was a licensed commodity. One fine evening, the state government said, no further transactions, no further sale. It was discontinued. No one can claim as of right that the license must be continued.
My lord,
Please come to para 28. What query we made that has been observed in para 28 in the affidavit of the state government.
My lord, in that particular case, as your lordship has already pointed out, my lord, the order of 1982, it provides a procedure for cancellation of license. My lord. And the
Yes,
and
of
the law is there.
cancellation. It's not a cancellation. It is not that a subsisting license has been cancelled. The tenure of the license came to an end and it was decided not to extend it any further.
But
It
there's
doesn't
a procedure,
tantamount
my lord,
to
that
cancellation.
Order 82, my lord, if your lordship comes to order 15 of that year, my lord, that it is specifically mentioned therein what is the procedure for cancellation license. When the law is there in operation, my lord, how can the policy override the provisions of law that is created by the state? If your lordship comes to that, well, the Assam Public Distribution of Articles Order 1982. If your lordship comes to Rule 15, Milan, there is the procedure.
Yes.
If any licensee or his agent or servant or any other person acting on his behalf contravenes any of the terms and conditions of the license, then without prejudice to any other action that may be taken under the Essential Commodities Act, his license may be cancelled or suspended by any order in writing or license by the licensing authority, and entry will be made in his license relating to such suspension and cancellation. Second clause, Milord, no order of cancellation shall be made under this clause unless the licensee has been given a reasonable opportunity or stating his case against the proposed cancellation. Milord, we made a representation before the respondents.
Sir, come
stating
to
everything, Milord.
clause 3 of this order, control order.
Yes, the licensee shall maintain daily.
Licensing authority may issue clause 3 of this control order.
Yes, the licensing authority may issue licenses in Form 1 to such appointed dealers as may be considered necessary from time to time, specifying wholesalers or retailers or the person.
Now come to next page. The fee for license, renewal of license and security money are as follows. Now they refuse, they have taken a policy decision not to accept the renewal fees offered by you. Does it amount to cancellation?
My lord,
Please tell us one judgment, please, sir.
I'll
The one judgment which says that there is a right to get the license renewed.
No, not in that way, Milord, not in that way.
Then
No,
this is
other-
a decision,
other
not
principles are
a
there.
decision of cancellation. You can't equate this decision to a decision of cancellation. If they had done it before the tenure term of your license expired, yes, probably you would have had a grievance. But a decision was taken that up to 31st March, no shops less than 50 will be permitted to operate.
No, in that case, my lord, we have made a representation before the additional director
Mm,
prior to the adoption of the cabinet decision, my lord.
mm.
At least our representatives should have been disposed of. Because we have a right of being heard, my lord. That
Mm.
cannot be denied. That is the law of the land, my lord.
Yes, all
At
right.
least that representation should have been. Another important aspect, my lord, I like to draw the attention of this court, my lord.
Mm,
Before adopting the cabinet decision, my lord,
mm.
if your lordship comes to page 84, my lord,
Mm.
85, my lord.
Yes, please.
It is in English rendering of the order of the additional director, my lord.
Mm,
That was 30th of May, 2020.
mm,
At more than 1 year ahead of that decision, my lord,
mm.
it was issued to the paper shop owners.
Yes.
May I read, my lord? You are hereby informed that as per shop owners having less than 50 families have to be attached with the nearby fair price shops.
Mm.
Therefore, as your fair price shop has not have 50 families, you are to inform the undersigned as to whether you wish to be attached to the nearby fair price shops or to surrender your license within 3 days of receiving this notice. Otherwise, I shall be compelled to take unilateral decision in this regard, my lord.
So they did not take it. You gave a representation.
Yes.
They waited for your term to be over and thereafter the action was taken not to renew. So
No,
again, this is not a case
My
of
lord,
cancellation.
the decision, if your lordship comes to earlier page, my lord, 84 page,
Yes, please.
that is the decision taken on August 2021, my lord.
Hmm. Yes, but the decision was never executed. You continue to operate till when? Please tell us.
But don't we have a right of being heard of our
Sir,
representation?
That is why we are asking you, is there any law which recognizes right of extension of license? Please tell us. That is what your case is, that we have a right that our license must be extended. Please tell us that law.
No, there you of course.
We just give you an example of driving license. Can you claim a right of extension? You will have to give a test. If you pass, then only you will be granted license extension.
No, driving licenses, of course, we are fulfilling certain conditions and say, for
So-
example, if I'm not deviating from any of the conditions, then
Precisely.
I'm entitled.
So
to
that is
an
why
extension
we
of
are saying
license.
that there is no right as such of having a license extended. Give us one judgment on that point, that there is a right of having the license extended. Then perhaps you can make out a case.
No, my lord, when the licensing order, that is the order of 1982, that is in existence, then without repealing, without amending, without modifying,
So that,
our-
sir, that's why we pointed
that was
out
a continuous
clause
practice
3
of-
renewal. Why does it contemplate renewal then? They decide not to renew.
No, they
Whether
have
that
already-
decision can.
They have renewed it for 25 years, my lord. As because we do not have any default. We are running the system. in a very
What was the
effective-
last date of your license? You yourself said
2022, my lord.
that's all right. Now they take a decision not to extend it any further. Less than 50. It is not that it is a random decision. All fair price shops closed. Now we will distribute it in a different manner. Not that. They have offered significant grounds and justifications which have been discussed in para 28. Please see. Viability, feasibility, all a rational decision has been taken. It's not that a random decision. Then they have accounted for,
One thing,
they have left the persons with disabilities and widows out of the purview of this decision. They've excluded them. So it is a very reasoned, justified decision, taking care of hardship of people as well as the viability, because the government was taking statistics that it has become unviable. That is the reason, sir.
no, my lord, they are, if your lordship allows me, then their contention is that it is the financial expenditure they are to bear. My lord, if your lordship comes to the food security assistance to state government rules, 2015, my lord. It is a 2021, my lord.
Yes. Provisioning of funds to state governments
Yes, sir.
for short supply.
No, it is rule 7, Miller, norms and patterns of central assistance.
इस बुक पर नहीं क्या वो तो बुक से पढ़ रहे हैं बुक कौन सी है ये दे रहा चलो दो give it.
Rule
Rule 7.
It is rule 7, Miller, norms and patterns of central assistance. There are two categories of states. One is a general category of states and the other is a special category of states. For the general categories, their allocation of fund is 70% or 65%, 70% like that. But then for special categories, interstate movement and handling, it is 100%, Miller. The state has to bear nothing, Miller. If you let's say come to the second page, they are close to special category of states and union territories. Next to Arunachal, Assam is the special category of states. So state is not to bear any expense because 100% benefit, the 100% fund is provided by the center, Miller.
Okay, very
Then
well.
another important thing in Miller,
Yes.
for installation of EPOs, Miller, if your lordship comes to rule 7.6, just next page, Miller.
Yes.
Rule 7.6, Milan, that is important, Milan. The state government shall have the flexibility in choosing any of the following models for the installation of the point of sale device. Namely, first option, the state may purchase, install, maintain point of sale device. Second, the state government may select a systems integrator to purchase, install, maintain. Third option, the private shop dealers may purchase, install, and maintain the point of sale device. My lord, in that case, if your lordship comes to page 54 of this appeal, Miller, page 54.
Yes.
It starts from page 53, Miller. May I read paragraph 14?
Yes.
In paragraph.
Sure.
That the petitioners beg to state that the ONORC, One Nation, One Ration Card scheme of the central government, prescribes about having one ration card by an individual, which will be applicable and valid all over all the states of the country. Under the scheme, a person having ration card in Assam can use the same in other states of the country by verifying the card of EPOS devices. Thus, the state scheme of the central government nowhere prescribe about closure of fair price shops having 50 or less than 50 ration cards and tagging them with other fair price shops having more than 50 ration cards, and hence the impugn policy decision of the state cabinet, consequential action thereon is bad in law. Further, such EPOs devices can also be installed in the fair price shops by the petitioners, and they are ready to bear the cost of such devices instead of adopting the policy to close down the fair price shop the petitioner. Because we have already volunteered that we'll bear the expense for installing that PM.
Very well. All right. Anything else to add, sir?
And in the judgment of the line of single judgment, if you also comes to page 320.
Paragraph, please.
It's on unread. You'll also paragraph 46.
Yes.
at page 347, Section 27 of the Act 2013 stipulates that all targeted public distribution system related records shall be placed in the public domain and kept open for inspection to the public in such manner as may be prescribed by the state government. Therefore, it would be seen that in terms of Section 3 of the Act of 2013, both the central and the state governments have been obligated to supply food grains at the subsidized rates stipulated in Schedule 1 of the Act of 2013. And in doing so, both the central and the state government have been further adjoined with the duty to see to that it is the beneficiary who received the benefit under the Act of 2013, and for that purpose, to apply information and technology tools, including end-to-end computerization, in order to ensure transparent recording of the transactions at all levels and to prevent diversion. As already stated herein above, it appears from the provisions of the Act 2013 that there is a shift in addressing the problem of food security from the welfare approach to the right-based approach. In the anterior to this judgment, this court has also taken into consideration that the various rules framed by the central government under Section 39 of the Act, reference has been made to the Assistance Rules 2015 in detail. We should show that the central government shall provide various forms of assistance to the state government in a manner stipulated therein, so that the state government is in a position to take delivery of goods under the targeted public distribution system from the designated depots and ensure its delivery through their authorized agencies up to the doorstep of the fair price shops, and further to ensure and monitor its supply to entitled persons and households at the prices specified in the schedule of the Act. Rule 7 of the State Assistance Rule 2015, as observed in detail earlier, stipulates the manner of assistance to be provided by the central government to the state government and the margins to be paid to the paper shop dealers for distribution of food grains. In the state of Assam, the margin to be paid for the paper shop dealers for distribution of 1 quintal of food grains is rupees 143 per quintal. Rule 7 provides confers the discretion upon the state government to choose any of the following models for installation of point of sale devices, and records herein would show that in the state level apex committee meeting held that is 17/2/2018, the government of Assam has adopted the system of integrated business model for purchasing, installation, and maintenance of EPOS device in the paper shops. It is also pertinent to note that Rule 10 of the assistance rule stipulates how and when the central assistance would be released. But another important aspect I'd like to refer to your lordship's attention. If your lordship comes to page 329 of the report, para 27 million. On the other hand, the respondent state had filed, there's a statement of the respondent, Millen, by submitted by London Advocate General. They said affidavit, taking into consideration are the common affidavit in respect of all the petitioners. It appears from the record that on 28 December 2021, the Deputy Secretary, Government of Assam, Food, Civil Supplies, Consumer Affairs has filed an affidavit. In the said affidavit, it has been mentioned that as per the decision of the cabinet meeting held on 30/6/2021, the respondent too was directed to take necessary steps for closing the paper shops having 50 or less than 50 cards, excluding the paper shops of such criteria belonging to Karbi Anglong and West Karbi Anglong and the Mahasab districts by the communication dated 30/7/2021 and 6/8/2021. it was mentioned that the said cabinet decision was taken to minimize the total project cost of the implementation of the purpose shop automation, which is necessary to implement one nation, one ration card as per the direction of the Supreme Court in Bandhu Mukti Morcha Chopra. Then, and the direction of the government of India was therein to direct the complete the scheme within 31st December 2021. It was mentioned that the implementation of one nation, one ration card is necessary, keeping in view the ongoing pandemic situation across the country in the interest of the migrant laborers. Further, it was stated that on implementation of the said scheme, National Food Security Act, ration card holders will get allotted their quota of food grains from any purpose shop anywhere in the country, for which every purpose shop shall have to be equipped with EPOs. It was mentioned in the EPOs machines will be held for eliminating bogus and duplicate beneficiaries by biometric authentication and will bring transparency to the public distribution system. Further, it was mentioned that in view of the large number of purpose shops in Assam, the total project cost has become unviable. Therefore, to minimize the total cost project, the cabinet has taken a decision to close the purpose shops having 50 or less than 50. It was further stated that the purpose shops having less number of ration cards will get minimum profit margin, which may not be the only source to secure them financially. For example, if 1 quintal of rice is distributed by a purpose shop to four ration card holders in the month, the owner of the purpose shop would get rupees 143 in 1 month. And in the manner in case of the purpose shops having less than 50 ration cards will get small amount, which cannot be the only source of his livelihood. On the other hand, for such cases, the government investment in EPOS devices becomes too high and unreasonable burden is thrusted upon the government's exchequer. Further, it was mentioned that affordable nutrition and nourishment assistance scheme, the state government is providing rice to the above categories of free of cost. Therefore, the keeping in interest of the migrant laborers, the government has initiated the process of implementation of effort policy one nation, one ration card. These beneficiaries would be eligible to get the allotted quota rice from fair price shops across the country. The state government therefore was planning to complete the one nation, one ration card by the scheme by 30th of December 2021. Malad, here, as they are talking about the expenditure or the cost bearing, the targeted public distribution system, as I already mentioned, Milan, a clause 9, clause 9.9, it provides that the state government shall allow the sale of commodities other than the food grains also, because that is also some sort of support to their sustenance that is there, Milan. It is not directly that only with the essential commodity that is supplied from the government side, that is they are running the affairs, Milan. So that itself is another important aspect, as I have already mentioned about the 2015 Rule 2021, the food security assistance. 100% assistance is provided by the central government in interstate transportation of the food grains, Milan. So from that perspective, Milan, so when 100% is provided by the central government, Milan, and another point, Milan, if a lordship sees the one nation, one ration card policy of the central government, nowhere it is mentioned that the state government or the central government will take a decision of reasonifying that above 50 card holders, the purpose shops will be retained, and with 50 and below 50 purpose card holders should not be.
Come to para 53 of the judgment.
Look, there is a conflict between the central
Please
policy
read.
and the state policy.
We have been raising that query without any answer. Please read para 53 of the judgment.
Yes, my lord, page 353.
Para 53.
Yes, my lord, that's
Yes.
page 53, 353. Before concluding, as regards the point of determination number one, this court would also like to take into account two judgments of the Supreme Court in Sankari Satta and then Anas Bhakreta Sangh, Tasil Bamitam and others, Chopra, Madhya Pradesh Ration Vikreta Sangha Society and others, wherein the Supreme Court categorically observed that the fundamental rights of the traders, like the petitioner therein, who were carrying on fair price shops to carry on business and foodstuffs, was no way affected. It was observed that the petitioners therein could carry or trade or in foodstuffs without hindrance to the dealers, only that they could not run fair price shop as agents of the government. It was observed that no one could claim the right on the right of fair price shop as an agent of the government, and at all that person could claim as a right to be considered to be appointed as an agent of the government to run the fair price shops. Here, Milan, as I have already mentioned about this rule 7.6, Milan, wherein there are three options. And we have already.
Government doesn't want to give you that option that you should purchase it. The government's view is that viability less than 50 is not working. When the statistics were collected, there were many shops which had zero ration cards. Still they have to be continued. Is that the intent of law?
No, no,
Please
that-
read the para 11 of Sarkari Sasta Anaj Vikreta Sangh, the judgment which has been cited.
My lord, my contention is that they can take a decision, but then that decision should be a region decision, Milan.
Okay, sir. Very well.
That decision should be a region decision.
Sir, we are asking you time and again, what is your right to ask for renewal of license? That you can come to the red court and say, no, we have a right that our license must be renewed. It's not a case of cancellation. Therein you could have challenged that cancellation has been done in violation of XYZ laws. But this is a case of renewal. As we said, we refer to that clause 3 from time to time. The single judge has discussed that also.
Yes.
Para 57. The licensing authority may issue license in form number 1 to such appointed dealer as may be considered necessary from time to time. Now the government considers it is not necessary to issue a license or renew a license to dealers having less than 50 ration cards. That's the reason decision. That is the very reason that we don't want such small dealers. There's an issue of monitoring. There are so many issues involved.
So then in that case, Milan, prior to adoption of this particular cabinet decision, Milan, 1 year and 2 months earlier, when that notice was.
But that
issued-
was never acted upon. You never challenged it.
No, we have made a representation to that.
Maybe so they acted.
But at
They
least,
did not.
at
They
least
did
we
not
have right-
execute the decision. They did not execute the decision. They were fair enough to wait for your term to expire and then they took the decision.
No, when the representation we have made, Milan, don't we have a right of being heard, Milan?
No. In a matter of renewal, you don't have a right. Whether to continue the agency or not is the discretion of the master.
So then in that case, the existing rule, Milan, orders 1982, that was framed under the statute of.
Sir, from that only we read you clause 3, which says time to time, as may be considered necessary from time to time. They took a decision that it is not necessary to continue. That is the discretion given.
All right, if your lordship is taking that, this one I have no.
Very well. Thank you.
Okay.
Yes, Mr. Bora.
And our affidavit, we have clearly stated, this is the decision taken to minimize the project cost, mainly to minimize the project cost. And we have not curtailed the right of the beneficiaries. The beneficiaries is getting the benefit only to minimize the project cost, because the system EPOS, it will help to control every ration card holder. Because one nation, one card, one person can claim anywhere in the country.
Anywhere in the country.
Anywhere in the country. This is a decision taken by the, my lord, cabinet. And cabinet decisions, they have no, the cabinet decision, we have already annexed with our affidavit. Page 117.
Yes.
This is a letter from secretary to the director for verification of the district-wise data on the number NFSA card holders against each franchise shop as per decision of the cabinet meeting held on 36/2021.
Yes.
With reference to the subject cited above and as per the decision of the cabinet meeting held on 36, I am directed to request you to verify the district-wise data on the number of ration card holders against each franchise shop and close the franchise shops having 50 or less NS50 cards, and thereafter take these card holders in the nearest franchise shops. However, the franchise shops in Karbi Anglong, West Karbi Anglong, and Dima Hasao district would be excluded from the above exercise. Collect the Aadhaar number of all beneficiaries of NSI Act 2013 in Assam and link into a National Food Security Act ration cards to enable government of Assam to smoothly implement the One Nation, One Ration Card. All beneficiaries of Food Security Act 13 in Assam shall compulsorily obtain Aadhaar cards within 31/12/2021 and submit the same to the official of Food Civil Supply and Consumer Affairs Department of Government of Assam. Submit proposal for implementation of the following. Quote, the cabinet decided that granting aid at 5 lakhs only per annum to ease of GPSS, LMPSS, WCSS be provided from the financial year 2021-2022 onward for service of rendered in the supply chain management of food grains. For this purpose, rupees 42 crores only shall be earmarked in the state budget annually from the financial year 2021 onward. The department will clarify.
That is
define
for the cooperative societies and lamps.
Yes.
We're not bothered about
Yes,
that.
Next, my lord, 6 August, that cabinet decision, my lord. Extract of cabinet decision.
That is
held on-
28 July.
Yes, 6th August 2021. This is the letter with reference to the subject. I am directed to enclose here a copy of the extract of the minutes of the cabinet meeting held on 28/7/21 and to request you to take necessary step for closing of FII shops having 50 or less than NFC Act 13 ration cards and we take with this next page. This is a cabinet extract of the cabinet, my lord.
The cabinet decision has been placed at 131.
Yes.
Why you are reading the abstract?
Yes, yes, abstract.
Hmm.
Yes.
Okay, very well. So what is your case? They say that we had a right of continuance.
Yes.
They were operating for 25 years.
Yes. No, my lord. My lord, section 10 of the Nation Food Security Act, my lord.
10.
10.
Yes.
State government to prepare guidelines and to identify priority households. The power already been vested upon the state government. The state
Prepare
government
guidelines, yes.
The state government shall within the number of person that power, and again, my lords, my lord, my lord, senior friend said that the representative has not been considered. This representation before, this is not, we are not curtail his right because we are allow him to distribute the ration card only. It is not his right, my lord, to claim to continue as for a long time. We have to, the state has to look after the beneficiaries, whether they are getting or not the ration card or food grains. The state is concerned only to that. Equally, we have to see the, my lord, to minimize the project cost. An e-post system.
Yes.
That my senior for affairs, section 27 disclosure of records of targeted public distribution system. This everything will be, my lord, now we get in the, my lord, e-post system.
They are
Because,
offering,
yeah.
they are offering that we'll buy it. We'll procure an e-post machine.
No, my lord.
Why? That's the provision of the act says, it gives them the option, it gives you the option to adopt any of the choices.
This is a decision of the cabinet lordship. Already the cabinet has taken a decision.
Whether the
But
cabinet has taken a decision, that no EPOS, only the state will procure. We will not give the dealer the right or the opportunity to purchase the EPOS machine.
No, my lord, this is 100%, my lord, scheme that we are getting from the central government. Because the EPOS system, it is linked with the central government, that everybody will know, yeah, just whether
Linking
this
is not a problem.
getting or not the benefit.
Mr. Bora,
My lord,
linking is not a problem.
my lord.
Even a privately procured machine would have to be tested, audited and linked with the central scheme.
No, another point is to control the bogus fair price by the license holder. Because as your lordship knows, so many, my lord, this bogus ration.
That
card
is why they're offered. We will procure the EPOS and then you can conduct an audit. What is wrong in it?
That, that, my lord, Allah, Nane Education will reply.
Argument, sir.
May I submit one decision of the non-Supreme Court, my lord? Yes. That is 2016-3 SCC 582. It is also renewal of license, my lord.
Yes, please.
Relating to railway catering. 3 SCC. 582. My lord, I'm directly coming to page 596, paragraph 25, my lord. May I read, my lord?
Yes.
The Article 14 of the Constitution of India mandates that the state action must not be arbitrary and discriminatory. It must also not be guided by any extraneous considerations which are anti-ethical to equality. The three judges bench of this court in Ramanna Dayaram Sethi versus International Airport Authority held under paragraph 21 is quoted here. It must therefore follow as a necessary corollary for the principle of equality enshrined in Article 14 that though the state is entitled to refuse to enter into relationship with anyone, yet if it does so, it cannot arbitrarily choose any person it likes for entering into such relationship and discriminate between the persons similarly circumstanced. But it must act in conformity with some standard or principle which meets the test of reasonableness and non-discrimination, and any departure from such standard or the principles would be invalid unless it can be supported or justified on some rational and non-discriminatory ground. Milan. Para 26, Milan. India is a welfare state. Article 38 of the Constitution of India, which is a directive principle of state policy, reads as under the state to secure a social order for promotion of welfare of the people. The state shall strive to promote the welfare of the people by securing and protecting the effectively as it may a social order in which justice, social, economic, political shall inform all the institutions of the national life. The state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities and opportunities, not only among the individuals, but also among groups of people residing in different areas or engaged in different vocations. Para 27. It is the duty of every welfare state to generate employment. Presently, millions of youths of the country are unemployed. The right to livelihood is a part of right to life, as has been held in Polgatelis. A vast majority of the unemployed population of the country then is susceptible to being exploited by rich and capitalists. It is the duty of the state acting through its instrumentalities to ensure that no person in a vulnerable position is exploited. Then Milan.
Sir, that was a case wherein there was a catering policy which allowed for renewal of licenses. And they too ultimately have been curtailed till 2023. Now no more renewal is being done. That litigation is before us. That has also come to an end. There was one-time measure granted. So renewal was provided in the policy. That was a judgment pertaining to that. Please read the preceding facts. Para 4. There was a provision for renewal of the catering licenses.
Yes. Your lordship saying para 4 of the judgment, Milan.
Yes.
Aggrieved the respondent association, the members of which had existing licenses, filed a writ petition before the single judge of the High Court of Judicature of Andhra Pradesh and at Hyderabad. The respondent association asked that the said action of inviting fresh bids is discriminated and also contrary to the provisions of the catering policy 2010. The main plea for respondent association was that in terms of catering policy 2010, the existing licenses were entitled for renewal of their licenses for a period of 3 years.
3 years, that's all, that's the cap. Not beyond 3 years. So herein there is no provision that you are entitled for renewal. This judgment rather goes against you.
No. Malad, reasonable, they are not classification should have been reasonable and
No, what is unreasonable in making a classification that henceforth we will not allow ration cards to be attached to such dealers who are having less than 50 consumers.
Malad, may I submit?
The distribution, the issues of distribution of food grains.
May I submit, Milan? The Article 42 principles are there. One is intelligible differentia. And what is the intelligibility based on which they have segregated above 50 and below 50?
Yes, yes.
It has to be reasonified. That is the decision of Honorable Supreme Court as well. And second point, once that is determined, what is the logical relation to the object short? Object short is to facilitate the people to get that at the doorstep, Milan. So that is the main, that is the
Once
main
the
object.
delivery at doorstep will start, the entire business of dealers may be stopped.
No, when.
The government will have their own measures then.
No, when, Milan, it is to be provided at the doorstep to the consumers. As your lordship is saying that the consumers are not.
Then all
before us,
right,
it is
the
not-
entire district, there will be one distributor, just like gas cylinders. They will distribute at doorsteps. No intervention of small FTS dealers.
But then
What is the requirement?
every consumer has to go to the EPOS stall and to get their ration card,
So-
get their rations there from.
So, all right,
Distance of 5 kilometers,
Does
7
that
kilometers,
not
9 kilometers.
Does that not happen if there is a dealer having less than 50 consumers? Is it not required? What is that argument? What is the context of that argument?
No, my
We are
lord,
not dealing with the, we
No,
are not
my lord-
dealing with the litigation that there should be a direction that now henceforth having zero ration cards attached with him should be allowed to run a fair price shop.
No, we are not going to support that, Milan.
There are people, that is the statistics. So after collecting all data, they have taken a decision. They have put up a yardstick that 50, less than 50 and above 50. And even in less than 50, they have excluded the widows and the disabled person. What more can be the reasonable decision?
No, as because somebody has.
An able-bodied
because of
person
which-
has to look out for himself. In that, those two Supreme Court judgments, the Honorable Supreme Court which are cited, Honorable Supreme Court said, carry on your normal business. Why you are so much dependent on the fair price business only? You are trading, you as you said, that you are allowed to trade in normal day-to-day life in the other articles, commodities. Do that. Lakhs of people in India do that. Trading in food grains. They are not dependent on the government supply. What prevents you? So what is your fundamental right? Your fundamental right is to carry on your occupation. Do that. No one stops you. But that doesn't give you a fundamental right to claim a license from the government for supply of the subsidized food grains, not the free food grains.
Malan, the government has taken a decision based on that some of miscreants are there where not a single.
That is not the single factor, sir.
So.
That is
we are-
not the
we are
single
clubbed
factor.
Together with them, Milan.
That is
those
not the
miscreants.
single factor.
We are clubbed together with those miscreants, Milan. We have not been discharging our
That is-
duties without, we have discharged our duty without.
That is not the solitary factor. There are more reasons. Anyhow, we'll consider. Thank you. Argument set, judgment reserved.
Lordship, if I may take your lordship's 2 minutes, your lordship.
Yes, sure.
There is a subsequent thing that has cropped up recently, your lordship. After this judgment, your lordship, and the close down of the shops having less than 50 licenses, your lordship, the government is issuing fresh licenses as well, your lordship.
Apply? What
Fresh
words?
licenses to the beneficiaries.
Uh,
So in that case,
Beneficiary means what?
to the end beneficiary, your lordship. There will be more number of card holders, your lordship.
So
So
what
in
of that?
case, your lordship, there were pending applications.
Oh, so pending applications should be treated. Get more licenses and apply when the shops are advertised. Garner more ration cards. You'll get opportunity to apply.
But that is not being done, your lordship. They are not allowing us to file any application for that.
Anyway, that's not the scope of this litigation, sir. Thank you. All counsel representing the appellants are here. Anyone wants to say anything? Mr. Burgoyne has addressed. Mr. A. Sharma,
I endorse the submissions of my learned senior counsel.
you are in item number 20,
Yes, 17,
20, 22, 23,
no. 17, 18, 19.
17, 18 also. Okay. What about 21?
My lord, I am appearing in 21.
Anything else to say?
My lord, I endorse the
Then there's Miss 27 senior counsel, Mr. Burgoyne, right?
27 and 28, I am here.
You are there, all right. 27.
Lordship 20, 22, 23, 24, 25 and 26 I am there. We adopt the argument of the senior counsel.
All right. Not clear enough. Yes. Pass.
Pass over matter, item 2.
Yes.
For my absence in the morning.
Why this appeal is not being decided?
My lord, they don't have an appeal pending with us. What they have is, they challenge the title of the land of a provincialized school in the name of the school. They filed a writ petition before this honorable court. This honorable court held that when the title suit is pending, the result of the title suit would govern the provincialization of the school.
But
They-
there is no appeal pending as.
With us, there is nothing pending.
Read page 78, come to page 70.
My lord. 78.
78.
Yes, my lord.
Do you find it?
That order had already been passed in an earlier representation, saying that this, since the land title is not yet declared by the court, the provincialization has to continue in the name of the person with whom the land remains. As of today,
Where is the order of the director
Yes.
deciding this appeal?
order of the director.
The appeal is at page uh, ninety-seven,
Page 121.
97.
Page 121, my lord, the orders passed.
Page 121.
121. After that appeal, they approach this honorable court. We
Okay.
disposed it of.
No, this is not the disposal of the appeal. Yes. With this, the Honorable High Court order passed in suit. It's not the disposal of the appeal, Mr. Mazumdar. It doesn't refer to any appeal. Page 123 come. That is the appeal. 4/12/21.
Yes.
Where is the order on that? This order is of October.
12/21.
Hmm.
After 4/12/21, they filed a writ petition. When this was not being, then at page 131, they filed it to the commissioner secretary,
Hmm.
not having been taken care of. With that grievance, they came to this honorable court at page 141. is the order. Now, Lordship would find
Okay.
the finding of the
You
court
say
on
that
page
the,
143.
since the writ petition has been filed, appeal, decision of
We
appeal
did
is
not take an action and what,
of no use.
and at page 143,
Hmm.
Single judge comes to the conclusion that after hearing the parties in the writ petition, the court is.
No, yes, there's a specific prayer to dispose of the representations. So that is what we are saying. What is the order of this single judge?
At page 143.
Oh,
After
right,
hearing the
right,
parties in
right.
the present writ petition, this court is of the considered opinion that direction given in WPC number so and so by the judgment and other so and so.
Where is the question of deciding those representations?
They.
That aspect has been taken care of by learned single judge.
If
What
they
do you
win the
say?
suit, we withdraw the provincialization. They lose the suit, provincialization stays. We need the school to function.
Yes,
Lordship, my limited submission is Mr. Boya is on lag at another court. So your lordship might take up the matter on another day or your
pass
lordship.
over. Let him come, call him.
Obliged, Lordship.
Ye judgment.
Item number 12.
May it please your lordships.
Yes.
My lord, the appellant is a registered cooperative society.
Hmm.
The same was,
Before is going to make it the case, my lord. He is yet to serve the memo of the appeal, my lord.
Wait,
today itself.
you have your seat. Yes,
Yes. In the year
Yes.
2000, my lord, some 75 acres of land was
Hmm.
allotted to the petitioner society for agricultural purpose. The land was found to be under encroachment of illegal encroachers.
Hmm.
So we were trying to get it freed through the department by law.
Hmm.
But till today, the same was not vacated.
Hmm.
So we approached this court,
Hmm.
and my lord, the learned single dismissed the petition on the ground of delay in approaching the court.
Yes, obviously.
Yes.
Why not?
Yes.
Why not?
Department was allowing the encroachers to remain for.
Why
all
the
these years.
department was allowing?
Yes.
Department had allotted it to you.
Yes.
Defend the land yourself. What is the responsibility of the department?
Possession was never handed over to us.
File a suit then. File a suit.
We cannot because the land is government
Limitation
land.
is gone.
Government land, my lord.
Is it your case that you are not given the possession? Let us see. Let's see your writ petition then.
Petition is
Let's see. The possession was never given.
in the petition is in the for the learned single judge, it may be called.
Read that possession was not given
It is not in the appeal, my lord.
in this writ petitions, gentlemen.
Paragraph 6,
Yes, please.
the.
Have you annexed the writ petition?
No.
You have not even annexed the writ petition with this. Why this appeal was registered?
Petition is not,
Why this appeal was registered, Mr. Jackie? They have not filed the writ petition, etc. Read your writ petition. What have you said about?
At
Not-
page 8, paragraph 6.
Yes, read.
That the writ petitioners could not approach this court earlier because of the fact that the land in question was not de-reserved by the concerned authorities for all these years, even after allotment of the same in the name of the petitioner cooperative society, and the said land was illegally allowed to remain in possession of unauthorized encroachers who did not have any right to possess the same.
Hmm. Yes. Why did you accept it? If it was an illegal encroachment, even before your
It was
allotment,
allotted.
why did you accept it?
We have not been given possession till today.
But why did you accept the allotment, sir? Tell us. Where is the allotment order? Let us see.
In the before in the writ petition itself, my lord.
But you did not file it on record. Why your appeal should be
I
entertained?
may be allowed to file the.
And counsel for the petitioner, appellant shall file all documents
Yes.
which were all pleadings and documents of the writ petition on record.
Obliged.
Copy of the appeal shall be provided to the government council
Also to me,
and MS Bodloi appearing for
respondent one.
respondent number 1.
Obliged.
List of 4 weeks.
Item number 13.
Well, in government affidavit, they say he attended these classes alone. In the fact situation, whether he can be permitted. That affidavit.
National Medical Council.
My lord, earlier occasion also lordship had a specific directed query at the NMC which regard to as to whether there is an outer limit to a learner or a student for completing an MBBS course, my lord. To which, my lord, the same had been addressed before the learned single bench, my lord, at page number 55, paragraph 5, my lord.
Yes.
That was a specific query. Page number 55, paragraph 5, my lord. Of the writ appeal.
Yes.
My lord. My lord, learned senior counsel appearing for the National Medical Commission as to whether there is a bar in respect to petitioner completing the MBBS course. Mr. Bora submits that under the Graduate Medical Education Rules 1997 as amended, a learner who has joined MBBS course prior to 2019-20 academic session, there is no bar in completing MBBS course. However, for a student who has enrolled after 19-20 academic session, there is a cap of 10 years for completing MBBS course. So this NMC has come into existence in 2018, my lord.
Okay.
Subsequently, this amendment has come. Earlier, the Medical Council of India had no such capped outer limits, my lord.
Okay.
Now, whatever lordship directs, my lord, will get on record.
Well, the stand of NMC is there. Stand of NMC is there.
Yeah,
The
no,
cap was not there earlier.
no, gap was not there.
Yes. Argue then.
Well, but only, well, not whether now because of the affidavit filed by the government accepts, well, we continue
Health department is filed everything.
Today.
Yes, today not.
today.
Copy is before not.
So do you want to controvert or?
No, they are accepting that he continued with the student. As your lordship,
Okay.
my lord, wanted to know,
Yes.
my lord, they are accepting that he is a student. He appeared in some internal examination. Only thing is that, my lord, fact situation, as your lordship will kindly say, impugn judgment. Impugn judgment, that last sentence, my lord. Because nobody has filed affidavit in my lord, this state council did not file any affidavit before the single judge. Last
So-
sentence, my lord, page
No, their
56.
case is, it will be a case of fresh admission.
Yes.
So after gap of 13 years, why you are to be given a fresh admission?
2012, not fresh admission. It cannot be. a
That's
case
what
of
they have
fresh
said in
admission.
affidavit.
Because, my lord, what I stated to the court is that,
Yes.
my lord, even persons who fails in several exams.
Failing is
they
a
are
different
allowed
thing.
to Continue.
Failing is entirely different. This is abandonment. This
Not
is an
that-
abandonment.
He was allowed to continue in the year 2012. He was allowed to continue in the year 2012. And I have shown one judgment, one paper cutting where the person, he was in jail for many years, for more than 10, 12 years. He was allowed to complete his MBBS course. So therefore, I
Where is
feel,
that
my lord,
pleading? Where is that pleading?
that page 45, I have given my lord, paper news cutting, my lord. That was placed before the learned
But
single
that is in a different state. We
Yes.
don't know what are the circumstances.
Lordship, Bangalore murder convict inches closer to realize MBBS win. My lord, therefore I submit, my lord, what they said that he cannot be continued or not. State government doesn't have the power, they say so in their affidavit. But therefore, I'm saying, my lord, let commission also give a affidavit to that extent, whether the petitioner can be allowed to continue. He was sick for 2019, my lord, he was, my lord, because of his ailment, various ailment, my lord, brain, spine injury and other diseases, my lord, he couldn't continue. That they are not controverting. my lord. The matter has to be decided by the commission. So let commission put their view in the matter. my lord.
Let the affidavit of the commission come.
My lord, with regard to this, my lord, whether under the lights and facts and circumstances, whatever the opinion of the commission is, my lord, I'll place this before this honorable.
All right, then counsel, your good name, please.
DK Boydo, my lord.
Because this is going to be impacted, my lord, all over. my lord. This is going to have an impact in.
Appearing for the National Medical Commission. Respond number so and so.
7, my lord.
7. Place foreign is granted. 3 weeks time to file affidavit.
Let it be 2 weeks, my lord.
2 weeks time to file affidavit on behalf of the commission. the affidavit in opposition has already been filed by the respondent number 2, which is taken on record, which may be brought on record. List of 2 weeks. Problem.
Deeply obliged, ma'am.
Item number 14.
In this matter, Lordship, I apologize, Lordship. May I pray for another date, your Lordship?
What is the matter about?
Lordship, we're challenging the rule of Assam prison rules, your Lordship.
Prison rules.
Lordship.
List of 3 weeks as prepared in council. Hearing now.
For hearing, item 30, supplementary list.
Yes.
May I please your lordship. Lordship, in the FIR lordship, the most important glaring omission lordship is the absence of any dying declaration. Lordship, first thing. Lordship, that has been already stated in the case of Ram Kumar Pandey lordship, that omissions of important facts in the FIR affecting the probabilities of the case.
Ram Kumar is a 75 judgment.
Yes.
Any later judgment?
Lordship,
This we pointed out. What you have done, what research you have done.
yes, lordship. Lordship, out of that lordship. Lordship, contradict, that is the only thing, lordship, that is the absence of the dying declaration.
Any later judgment, gentlemen, what research have you done? How do you justify your brief?
Lordship. There are 3-4 points, lordship.
They are
Generally-
asking you judgment.
Yes, lordship. No, later judgment, lordship. that
There are
is
no
only-
later judgments. Are you sure?
There are later.
Whether Ram Kumar has been followed or distinguished? What has been done?
Lordship, Ram Kumar has been followed by other judgments later on, lordship.
Which one?
2010, 2018, there are judgments, lordship.
What has been said in those judgments?
Lordship, the thing that has been said, lordship, that is,
2018, have you given the citation?
it's, lordship, I'll bring the citation, lordship, but I have not got the citation today.
You are an amicus in this case or a representing counsel?
No, I am just a junior representative.
How do you ultimately justify your briefs, gentlemen? We gave you the opportunity other day.
Lordship.
You are not aware of this argument. It's a
Yes, lordship.
fact.
Yes, sir.
We put it you across
Lordship, yes.
that this is the argument. And not,
Only-
despite that, you are not prepared
In
with any
2000
judgments, any law on that.
Yes, lordship. Actually, only briefly it has been mentioned in other cases, lordship. That's the only thing.
Carry on whatever you want to
Yes, sir,
say.
lordship. Lordship, the first thing is that there is no mentioning of the dying declaration, anything. So the point being that the whole ordeal was narrated to the informant in this case, lordship, by the PW2, that is his brother, lordship. Had it been, lordship, that the victim himself had narrated the whole incident, he would have himself told about that while narrating the whole FIR, lordship, while giving the FIR. That is the absence of dying declaration, lordship, in the FIR, firstly. Secondly, lordship, there is that the conduct of the accused, lordship. Regarding the conduct of the accused, lordship, there is a judgment of Sujit Biswas versus State of Assam, that is 2013 SEC 12406 law. I brought the judgment.
Yes.
Yes, lordship. With regard to it, lordship, abscondence by accused appellant against whom FIR has been lodged under lordship 302 of FIR, him having an apprehension that he may be apprehended by police is not said to be unnatural in the said circumstances, lordship. That was told, lordship.
In page number 5, Lordship, para 18, the court must consider a case of circumstantial evidence in the light of the aforesaid settled legal propositions. In a case of
This is not a case of circumstantial
not
evidence.
circumstances at all, Lordship. But here, Lordship, in para number 22, whether the abscondence of an accused can be taken as a circumstance against him has been considered in the case of Bipin Kumar Mondal, that I also have that. Bipin Kumar Mondal was a state of West Bengal, wherein the court observed, that is, in Matru versus State of UP2 SSC, that is para 27, the court repelled the submissions made by the state that as after commission of the offense, the accused has been absconding. Therefore, the interference can be drawn that he was guilty person, observing that under the appellants, that is the appellant, next page, Lordship, that is page 7, the appellant's conduct in absconding was also relied upon. Now, mere absconding itself does not necessarily lead to a firm conclusion of guilty mind. Even
Yes.
an innocent man may feel panicky and try to evade arrest when wrongly suspected of a grave crime, such as the instinct of self-preservation. The act of absconding is no doubt relevant piece of evidence to be considered along with other evidence, but its value would always depend on the circumstances of each case. Normally, the courts are disinclined to attach much importance to the act of absconding, treating it as a very small item in the evidence for the sustaining conviction. It can scarcely be held as a determining link in completing the chain of circumstantial evidence, which must admit of no other reasonable hypothesis that of the guilt of the accused. In para 28, abscondence by a person against whom FIR has been lodged, having an apprehension of being apprehended by the police, cannot be said to be unnatural.
Yes.
Yes, Lordship. Thus, in the view of the above, we do not find any force in the submission of that mere absconding by the appellant after commission of the crime and remaining untraceable for such a long time itself can establish his guilt, Lordship.
Yes.
So the point being, Lordship, that his abscondence cannot be just held to be as his establishment of guilt, Lordship.
Yes.
This is my second point in this case. Lordship, thereafter, Lordship, the third thing is, Lordship, the PW2, the deposition of PW2, Lordship, during his cross, that is page 13 of the paper book, Lordship. During his cross, Lordship, he himself during his cross has stated that during the last para, Lordship, police did not seize bicycle of my father. Police did not seize kukri nor try to recover from the jungle. It was a little dark at the time of incident at about 6:30 p.m. At the time of incident, I was in my house along with my wife, my mother, and 1.5-year-old child. Lordship. Lordship,
So he doesn't claim to be an eyewitness.
Yes. No.
Why, what is the relevancy of this question?
Lordship, relevancy is that his father, as per him, Lordship, his father narrated the whole incident to him. When that the victim's wife was present, his own wife was present, neither they were made prosecution witnesses, neither they have been made anyone, so that they could have been corroborating the whole ordeal regarding the fact that there was some dying declaration that was made in regard to by the victim to the PW2 that would have corroborated the whole. They were not made any witnesses, Lordship, in this case.
Yes.
Yes. Now, Lordship, coming to page number 16, that is the deposition of PW4, that is the IO in this case, investigation officer of this case, Lordship. He is an ASI, Lordship. First of all,
Does it
Lordship,
make
he has
any
not
difference?
filed any authorization letter.
Is there any requirement in law that ASI can't investigate?
Lordship,
Or the investigation by ASI would vitiate the proceedings?
Lordship, as per, he has to have authorization because ASI.
Which law?
Yes,
It is not an NDPS recovery.
yes, Lordship.
Then
But still, he is generally in Lordship in police manual,
which provision of police manual, gentlemen?
Lordship, Assam police manual, Lordship.
Which rule?
Uh,
Which clause? And then argue, come out with a law that it vitiates the investigation. It's an irregularity, not an illegality.
Yeah.
It's It's an irregularity.
It does not vitiate the. whole,
Then what is the,
investigation. Lordship.
does it affect the quality of the evidence collected by him?
No, Lordship.
No, then,
No, Lordship. Lordship, in his statement in page 17, Lordship,
yes.
page 17, Lordship, the same deposition of the paper book, Lordship.
Mm.
uh, The FIR was filed on 28, Lordship, where he himself stated that the injured was brought to Kosugao PS. His statement could not be recorded as he was in a serious condition and he was not in a position to give statement, Lordship.
Mm.
That is the first thing, Lordship. He was not in a position to speak at that point of time and the statement could not be recorded.
Mm.
He was taken to 2-3 places, his statement was not recorded.
Mm.
Thereafter, Lordship, in the next para, Lordship, I did not see any wearing apparel of the deceased as he was brought to the PS in an injured condition and he was immediately referred to Kuzviar Hospital. I did not insist the informant side to see wearing apparel of the deceased and bring any clothes for him. I did not record the statement of other family members except sons of the deceased. I have not recorded the statement of other villagers except Lohen Bosumatari. I have not recorded the statement of the doctor of Kosugao PSC where he was initially brought, though I inquired him verbally. I furnished one requisition to the doctor for recording dying declaration of the deceased. The requisition note is available in the KCD, which is received by the doctor of PHC. So, Lordship, even after giving, the doctor did not record any dying declaration, the Kosugao PHC. Thereafter, Lordship, on page 18, neither he had any, that earlier only I have told Lordship that neither no weapon was found also, no recovery, non-recovery of weapon. Thereafter on page 18, Lordship, I have not collected the medical report from Kosugao PSC. I have not visited to an RNB Civil Hospital. It was not reported to me that the injured was initially taken to RNB Civil Hospital. It is not a fact that I have not investigated the case. So this is page 18, Lordship. So in this case, Lordship, the first of all, in this case, Lordship, there is a judgment of 2011, Lordship, 2011 SCC 13-125, that is Waikoma Yama Singh versus State of Manipur.
What is it? Principle laid down?
Lordship.
Yes.
Lordship, page 5, Lordship, paragraph 20. There can be no dispute that the dying declaration can be the sole basis for conviction. However, such a dying declaration has to be proved to be wholly reliable, voluntary, and truthful, and further that the maker thereof must be in a fit medical condition to make it. The oral dying declaration is a weak kind of evidence where the exact words uttered by the deceased are not available, particularly because of the failure of memory of the witness who have heard it. In the present case, also, the exact words are not available. They differ from witnesses to witnesses. Some witnesses say about the name of the village of the appellant having been uttered by the deceased and some others do not. Further, doctor, which is prosecution witness 12, was also not cross-examined by the public prosecutor in this case about the medical condition of the deceased and further fact as to whether he was in a fit condition to make statement. So, in our present case also, there is a non-examination of the doctor who had conducted the PM report, Lordship. Thereafter, Lordship, para 22 of the same case, Lordship, if under such circumstances, the trial court felt it unsafe to rely on the so-called dying declaration, we do not think that the trial court was not justified in taking that view. In our view, a perfectly probable view has been taken by the trial court, which could not have been set aside for the mere fact that some other view could have been taken on the basis of the dying declaration. We are at a loss to understand as to how the High Court held in para 26 of its judgment that the victim was in a fit state of mind to make that declaration. In fact, there is absolutely no evidence about the fitness of the victim to make the said declaration. In our case also, there is non-examination of the doctor who had conducted the examination, the PM, post-mortem of the victim, Lordship. Lordship, another case, Lordship, that is persuasive, this is a Jharkhand one, Lordship, that is Sohan Kisku versus the state of Bihar, Lordship. Lordship, the page 2, Lordship, para 7. We are unable to understand as to why the prosecution did not choose to examine the doctor. It is no doubt true that in spite of the steps taken, the prosecution could not procure the attendance of the doctor who conducted autopsy over the dead body. But that could not have precluded the prosecution from examining some other doctor from the same hospital who knew the handwriting and signature of the doctor who conducted autopsy. If any other doctor would have been examined who knew the signature of the doctor who conducted autopsy, and if he had given evidence as to the nature of the postmortem done and the injuries found by the doctor on the dead body, then the appellants could have had an opportunity of examining the said doctor to say that injuries suffered by the deceased are not fatal in nature, and even if the deceased died on account of such injuries, the accused appellants could not have taken a defense to say that the said injuries are not sufficient in the ordinary course of nature to cause the death of the deceased, or that the said injuries are only likely to cause the death. The prosecution, by not examining the doctor, denied the opportunity to the accused appellants, as they were prevented from cross-examining the doctor. Therefore, the absence in any evidence that died due to homicidal violence, we cannot find the appellants guilty of murder, Lordship. Lordship, again, in para 8, Lordship, there is a discussion regarding, Lordship, a perusal of section 60 of the Evidence Act shows that in all cases, wherever it refers to an opinion or to the grounds on which that opinion is held, it must be the evidence of the person who holds that opinion on the ground, and the prosecution, having not examined the doctor and not giving an opportunity to the accused to cross-examine him, cannot rely upon the evidence of PW 11 and Mark Exhibit 5. The PM certificate through him. It is needless to mention that the doctor who conducted and expressed opinion in the PM certificate was not examined, and therefore the compounder PW is not a competent witness to speak about the cause of death.
What has been done? Yes, whether the doctor was cited as a witness. Have you tried to check the record?
Yes, Lordship, it was the PM report was exhibited, Lordship.
We have put a simple question,
Lordship,
whether the doctor was cited as a witness or not.
Lordship, with regard to that.
You saw the. Okay. That is all right. Many times what happens is the doctor is cited. They can get him in the. No, that's what I'm just, yes. Yes. Okay, carry on, carry on.
Lordship. Lordship, thereafter, at this stage, we wish to make a useful reference to section 293 CRPC, which contemplates that any document purporting to be a report under the hand of a government scientific expert to whom the section applies, upon any
Yes,
matter
we
or
were
thing duly submitted to him for examination or analysis, and report in the course of any proceeding, may be used as evidence in any inquiry, trial, or other proceedings. Subsection 4 of section 293 classifies the report of the scientific expert. Post-mortem report is not one of those documents which falls under subsection 4 of section 293 of CRPC. Lordship. So, Lordship,
Whether the evidence was closed, let's see. The order sheets check करना पड़ेगा. 14/11/2018.
Lordship, para 10 of the same
Yes.
judgment. In this background, when we look at the provisions of section 294 CRPC, it could be seen that if any document is to be filed before the court by the prosecution or the accused, the particulars of every such document shall be included in a list, and the prosecution or the accused, as the case may be, shall be called upon to admit or deny the genuineness of each such document. The list of documents shall be in such a form as may be prescribed by the state government. The prosecution not having taken recourse to section 294 and the post PM report having not fallen within the ambit of section 293 cannot examine the compounder for making the PM certificate to establish the cause of death of the deceased.
Yes.
In our case, Lordship, nobody has been examined with regard to the PM report. Only the PM report has been exhibited by the ASI, by the IO Lordship.
Yes.
Nobody has exhibited, only the ASI has exhibited the thing, Lordship. Thereafter, Lordship, page 19 and page 20, Lordship, that are the deposition of DW1 and DW2, Lordship. Thereby, he himself states on oath that I inquired Bimal and he was not, DW1 in page 19, it is stated that I inquired Bimal and he was not in a position to talk. Bimal was in unconscious state. Thereafter, in page 20, he states that when we reached the house of deceased Bimal, we saw him in an injured condition. His family members were trying to move him into the veranda of the house from the courtyard, and he was not in a position to talk with us.
Yes.
The same persons who had gone there when the prosecution witness 3, who himself stated that he had seen him speaking, Lordship, at the same point of time, they themselves are stating that he was not in a fit state of mind or he was not in a conscious to speak. Lordship. My only point of argument, Lordship, is that neither during the initial time, there is the first thing is that the first dying declaration, which was not spoken, or neither it was informed by the informant to the while dictating the FIR, Lordship, which is a glaring thing. Second thing is that when the whole thing was narrated to PW2, there were other people being present. They could have corroborated the whole dying declaration, which was not done at all. Thirdly, Lordship, the ASI has neither recovered any murder weapon in this case, neither when the victim had gone to the police station, he was not in a fit state of mind. He himself dictated in the, he himself stated in the cross-examination in his deposition, Lordship. And thirdly, Lordship, non-examination of the doctor who conducted the PM report has been fatal in this case.
Okay.
That is my only submission, Lord.
What I have gathered from the submission made by my learned friend appearing for the defense, your lordship, there's omission in the FIR, my lord. There's non-seizure of bicycle and other materials. your
Forget about
lordship.
the season.
My lord.
Doesn't make any difference.
And disease was not conscious. And there is a non-examination of the doctor who conducted autopsy is a fatal to the prosecution. May I take your lordship first to the FIR, whether there was a actual and omission regarding the dying declaration.
It's all right.
Lordship, page 4. I have the honor to inform you that I, Shri Rajendra Bosumatari, son of Bimal Bosumatari, inhabitant of Amlaipuri Post Office, Gonijia, would like to inform you that yesterday around 6:30 p.m., while my father, namely Bimal Bosumatari, was coming from Hellbridge Bazaar by bicycle, suddenly he was attacked on the way middle of the Dodua Gate near the Gongia River by Shri Somna Boro. According to Lordship, can you note this part? According to Bimal Bosumatari, Somna was trying to be destroyed him. So this is as regards the dying declaration, my lord. Although it was straightway not talk, it was not disclosed to him because he.
Your case is very specific.
My lord.
Dying declaration was made to PW2.
PW1, he is the resident of another village.
So what is the source of this information?
That source is not there, my lord.
That is
but
what the dying
regarding
declaration. It's an oral dying declaration.
Oral dying
That is
declaration, my
why
lord.
a stronger proof is required.
Lordship. So
Carry
your
on with the
lordship,
FIR.
whether the accused person.
Carry on with the FIR.
Yes.
Whether the accused? Yes.
Somna was trying to be destroyed him on the spot. Only, but somehow Bimal Bosumatari was escaped from the hand of Somna Boro. And my
How was he trying to destroy him? How was he trying to destroy him?
That description is not there, lordship. It may be taken as an omission, may not be fatal to the prosecution case, your lordship. Because
What
your
was the
lordship,
manner?
PW2,
You see,
my lord.
trying to destroy him financially, destroy him mentally, destroy him
Is it
physically.
my lord.
Is there any
That
presumption?
specific place, not specific environment is not there.
Stabbed by a kukri, that is the dying declaration.
Lordship,
By-
education is there,
That
but
is the dying declaration
my lord,
as per PW two.
yes,
Where is that narration?
PW2, your lordship,
No, where is that narration in the FIR?
that is
Stabbed
not there.
by a
That is not
kukri.
there.
No,
Lordship,
madam,
that part is
madam,
not there.
the FIR is lodged on the next day.
Yes.
There is ample time for the family members to consult. So if PW two was told by his father that X has stabbed him by kukri, then whether his brother who
Resident of
reached the
another
home,
village.
he
Resident of
reached
another
home, he was
village.
given the information. He was given the information, then he lost the FIR.
On the next date, your lordship.
He got this information from PW two, then he lost the FIR. In that event, whether the omission doesn't become material.
Lordship, but your lordship will kindly consider the mental state of the family of the victim.
So what?
Lordship, they have taken this one, the victim to a nearby medical, it's on record, my lord.
Where he
nearby
was not,
hospital, he was
not admitted.
treated.
All right, read the FIR now.
Lordship,
Read the FIR. Where was the deceased when the FIR was lost?
lordship, as per doctor report, we need to further quality doctor, that sir, on behalf.
And my father was immediately admitted to Kuchgaon Block Primary Health Care. Still, my father is very serious. As per doctor report, he need to further quality doctor.
Yes.
Where are the documents of Kuchgaon Primary Center? Then your case that he was denied medical treatment falls flat in view of this government in the FIR, which was not pointed out by counsel.
Lordship,
Miss Counsel, we must tell you, you are a young man who is supposed to work on briefs. Is this the manner of arguing?
lordship, next point, lordship, whether
First explain this. Where are the documents of that hospital?
it's not there, your lordship.
It's not there. All right. Next point.
Next point, my lord,
What is the cause of death?
due to stabbing, that
Who says so?
lordship, may I take your lordship to the evidence of PW2? Who is the first person before whom the oral dying declaration was made?
Oh.
Third line,
Is his oral version sufficient to prove stabbing? He's not an eyewitness.
he is not an eyewitness.
So he says that he was told by his father.
Yes,
Whether his father was in such a condition
yes,
to make a dying declaration.
yes, your
Who says so?
lordship, after reading PW2, may I take your lordship to the evidence of DW2?
Definitely,
PW2,
definitely. Read.
lordship, there are two DWs, your lordship.
Mhm.
First, married with DW1. I knew the deceased at page 19. I knew the deceased Bimal Bosumatari. I also know the accused. Deceased is not resident of our village. I think the deceased was belonged to Jaragaon. On the day of the incident, I was present at the Hillbridge Bazaar. I was returning home at about 6:30 PM from the bazaar. The person who accompanied me to the court today as witness are also with me when I was returning from the bazaar. At the time of incident, it was raining and we saw the deceased in an injured condition lying on his courtyard. We heard halla in the village and accordingly we reached there and saw the injured Bimal. I do not know about the incident. I inquired Bimal and he was not in a position to speak. Bimal was in unconscious state, whereas lordship may leave.
No
another.
cross-examination.
Lordship 20, page 20.
No
DW
cross-examination.
no cross-examination.
Right?
And DW2,
Yes.
page 20. I knew that this is Bimal Bosumatari. I also know the accused. He belonged to our village. The village of the deceased was near to our village. The incident took place about 5-6 years ago. At about 6:30 PM, I myself, along with Enla Bosumatari, that is DW1, were coming from Hill Bazaar. Our village is about 5-6 kilometers far from the Hill Bazaar. At the time of incident, it was raining, so we moved in slow speed. And we saw, lordship will kindly note this part. Deceased Bimal was running in front of us. So lordship will kindly consider this aspect. He was in a state of running, my lord. We visited to the house of deceased Bimal, keeping our bicycles. So in between, there's a gap. They have gone home, kept their bicycle in their house, and they came back. By that time, your lordship, there was oral dying declaration made before PW2.
Okay.
So lordship,
Very well.
there's a
Yes.
gap, your lordship. So
Yes.
your lordship, may I submit, there's a, the accused was, the deceased was in a fit state of mind to make the oral dying declaration. My lord,
Come to PW two.
my lord,
Whether his presence is proved,
yes.
read
Page 9. Peter, no,
Yes.
not page 9,
page 12.
page 12.
Yes.
Informant is my brother and I know the accused. The incident took place on 27/8/13 at about 6:30 PM. On the day of incident, my father was coming from Hillbridge Bazaar after closing in medicine shop. He was in a jungle road and when we reached near Gongia River, accused asked money from my father. And when he refused to give money, the accused stabbed my father by kukri in different parts of his body. He gave 3-4 blows on his head, face and other 7-8 blows on the entire body of my father. While accused stabbed my father, suddenly the kukri fell down on the ground. And when the accused was trying to search out the kukri, my father somehow managed to escape from the place with severe injuries on his whole body. At that time, I was in my house and my father reported me that accused Somnath stabbed him near Dodua Gate. I initially took our father to RNB Hospital, Kokrajhar, but doctor refused to provide treatment without registration of the police case. And then I brought our father
So,
to
no, madam,
my lord.
how many injuries were caused as per him?
How many injuries, my lord?
Yes. 3 to 4 blows on the head, face, and 7 to 8 blows on the entire body.
My lord.
No, we will have to seek corroboration.
Yes.
Now read your postmortem report.
Postmortem report at page
Yes.
25,
Come to page 46,
47,
47.
my lord.
Description of injuries.
Yes.
How many injuries are there?
Surgical stitches with silk were noted left cheek on this section, one sharp cut injury. Noted size so and so, bone deep. Surgical stitches with silk noted in forehead, on cheek, lordship, over cheek, over forehead. On this section, one sharp cut injury is noted size so and so, bone deep. Surgical stitches, one dissection, one sharp cut injury was noted, so and so. Clotted blood into brain tissue was noted.
So 3 injuries.
Lordship.
So now your witness says 3, 4 on the head, 7, 8 on the body.
No explanation, but whether, lordship, the veracity of the postmortem report, which was not admittedly exhibited by the doctor concerned, by the IU, my lord, whether it was confronted, whether they say, their lordship, that this is doubtful, your lordship.
Why are they supposed to confront? It is your duty to
Under
prove the prosecution.
3, your
It
lordship.
is your duty to prove the postmortem report. Whether your ASI was competent to do so. Does he know the handwriting of the doctor?
He doesn't.
No.
But those pleas they have not taken in trial, my lord.
Why were they supposed to? This is an appeal. They can take any plea under the sky.
They can.
Then
But once.
they had taken the plea. The
Lordship,
trial court did not accept it. That's a
Lordship,
different matter. Why
lordship,
didn't you produce the doctor?
lordship, requisition was given even to, lordship, registered, lordship,
Registered summons was sent. Is that sufficient? Why didn't your police officers go and summon the doctor and bring him into court?
that was not done.
That was not done. Who is to be blamed for that?
Lordship, the prosecution as well as the lordship is the duty of the court also, your lordship.
Court issued summons on your saying. What else the court could have done? The court could have gone there and recorded a statement on commission.
No, your
Then
lordship.
what was the court supposed to do?
Lordship,
When the evidence was closed on 14 November 2018,
my lord.
you should have come to the High Court challenging the closure, or you could have filed 311. Why didn't you do that?
Lordship, for the end of justice at this stage also, your lordship may.
Why should we? Why should we? If you had find any other substance in your case, then perhaps you would have been persuaded.
Apart from that, your lordship.
Then ends of justice. 391 is a
Yes,
provision.
Your lordship.
Madam,
My lord.
391 is a provision available to the prosecution as well,
Yes, ma'am.
right? Why didn't you move the application? When was this appeal filed? What is the year of the appeal? 2019. For the ends of justice, what the prosecution was doing for 4 years. Sleeping in a deep state of slumber. That's correct. We'll record that.
May not be recorded, my lord. Lordship, but one aspect your lordship will consider the apathy of both the sides, my lord. Lordship,
We
the
understand,
victim
madam.
also, your lordship.
We understand. But had there been any such circumstance which could have convinced us that there is a possibility of accepting your story, even if the doctors comes in? Yes. How do you explain that line in the FIR? My father is admitted in Kuchgaon Primary Health Center. Why didn't your IO make investigation into that? Pokrajar, your, and that fact is corroborated. Tried to refuse to provide treatment without registration of police case. Then I brought our father to MRM hospital. That is probably the Kuchgaon hospital. Why was that doctor not examined? Where is the medical report? At the time, when the doctor applied the stitches, what was the condition of the deceased?
Lordship, page 17, there are certain, Lordship, page 17. I have, last 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 line. I have not recorded a statement of doctor of Kochugao PHC.
Yes.
Do I
So-
inquired him verbally?
Where is the statement? Why the doctor was not cited as a witness? Now we don't even know who the doctor was.
He said, I furnished on requisition to doctor for recording dying declaration of the deceased.
So,
The requisition note is available in the CD.
so now that is immediately after the incident.
Yes.
The doctor
The first
says,
doctor.
doctor says not fit to give statement.
Yes.
Then why should we believe your theory of oral dying declaration?
Lordship, but there's no certificate to that effect. I have not gone through the case study.
What certificate? Your IO says so. Your IO says so.
Lordship, doctor also received a requisition and thereafter he was referred to patient Kuchbihar for better
Yes,
treatment.
yes.
Do I have the requisition Kochugao PSA for recording dying declaration of the deceased, but it is not mentioned in the CD.
Hmm.
I have a requisition which is available in the CD. Lordship, may I, if the Lordship permits, may I see the case?
Case diary will not be in this record. Case diary is always in the custody of the public prosecutor.
One part is there.
Case diary can't be there. Give it, give it. We read the SI once again. The injured was brought to Kochunga PS, but his statement could not be recorded as he was in a serious condition and was not in a position to give statement. It is your witness who is saying so.
May I still pray, your Lordship, for the end of justice, if your Lordship may send back for recording the
What
evidence of the
purpose?
doctor?
What would be the purpose to be served, to be achieved? Tell us. Whether your dying declaration can be accepted. And unless the dying declaration is provided, is proved, what is the evidence?
It's an oral dying declaration, there is no.
So if that is not reliable, there is no other evidence. We'll take note of your prayer while recording that the prosecution was grossly negligent,
Lordship, may I?
even in the trial and in the appeal. For 4 years, you did not make any effort.
Lapses on our part, but that may not be observed.
You are making a submission, we'll have to observe it.
Lordship.
All right, we'll take that. We'll take note of your.
Lordship,
Hmm.
could I cite it?
Of course, yes. Citation on what point?
Uh,
Come, first give us citation on omission in FIR.
Omission in the FIR, may I cite one judgment regarding the mental state of the victim's family? There might be omission. I don't say there's
Omission of
omission.
trivial details, all right, understood.
Details is not there.
This was a major factor in your case. This was the only factor on which you are banking upon. The fundamental fact of your case. Deceased while he was in an injured condition, made an oral dying declaration, which is missing. So whether that is a trivial,
Try to destroy him, my lord. That part can be taken as a.
tried to destroy him, who told this Rajendra that this
No, informant was not told.
So-
It was told to her, to his brother.
yes.
And
So
informant
whether-
lordship, we kindly note one aspect. Informant is a resident of another village, whereas the victim as well as the, yes.
We again will again repeat to you that the brothers consulted with each other.
Yes.
It can be presumed,
Yes, yes,
right?
yes.
So the FIR was lodged after consultation. In that event, that is why 75 Supreme Court. Read that judgment.
Yes.
You will understand what is the
Yes, my
law
lord.
relation to omissions.
My lord.
Okay.
Obliged.
Judgment reserved. Yes, you want to say anything?
No.
Okay. Need to be better prepared. in next-
Regarding one more is the abscondence part, my lord. He went missing. He was absconding, my lord. That can be taken into account.
All right, so that is the only circumstance proved. What happens?
After 5 years, he has surrendered, your lord.
So we are saying that is the only circumstance proved. What of that? What efforts did you make to arrest him? 82, 83? Did you resort to 82, 83? Did you proclaim him?
Yes, yes, yes.
Proclamation.
Proclamation is there.
Let's see
Report of proclamation is page 50.
whether any 82, 83 was resorted to. What is 82, 83? Do you know?
I am not the expert, your lordship criminal. I'm trying to learn, my lord.
Read 82 CRPC.
Proclamation for person absconding. If any court has reason to believe whether after taking evidence or note that any person against whom a warrant has been issued by it, it was
Whether
absconding.
did you get a warrant issued against him?
Yes, yes, then thereafter.
Let us see. Where is the warrant?
Lordship, page 50. I have the honor to state that I have attempted to several times to execute a warrant of arrest against his Somna Boro, so and so Kosuga, but could not execute the warrant of arrest as he was not found available at the opposite address. Is absconding from his house, and during questioning, the family members as well as his neighbors also could not state his present location, hence arrest could not be made.
Okay.
I have the honor, lordship.
Okay, very well.
It was affixed, my lord, copy of the proclamation affixed in a conspicuous place.
Steps said thereafter were required to be taken to attach his properties. That is the completion of the procedure.
My lord.
Very well. Okay, thank you.
Item note 31.
Read 313 statement. Nothing to be done beyond that.
He says he fell, the wife fell down.
Fell down on the bed and received that kind of injury.
Well,
Is that explanation to be accepted?
If your lordship reads it along with the postmortem, other than the injuries in the cheek, my lord, there is nothing.
Entire rib cage is
Rib
broken.
cage is there, my lord.
So by falling on the bed, that kind of injury can be received.
Explanation, but can it be said that it has been proved beyond reasonable doubt?
106.
106 is there, my lord. No
That's
dispute,
all.
106 is there.
What else is required?
But it could, my lord, it could be a case under 304, my lord. My endeavor will be to
Why? Why
appreciate.
is that? Why is that so? Even after causing those injuries, you made no effort whatsoever to provide her medical aid.
No, it is me, my lord. I ran to the PW2 and 3 is clear, my lord. I ran to them, they will call the ambulance, my lord.
But she was already dead.
No, my lord, she was taken to the hospital.
Mm.
Lordship, will kindly come to the PW2, my lord, page 10.
Yes.
10 and PW2 and 3 are husband and wife, my lord.
Mm.
I know the informant of this case as he is my neighbor. I know the accused person. I used to know the deceased so-and-so who was the daughter of the informant. The incident had taken place in the year 2015. At the time of incident, Asha Bhumis used to reside with her parents, but she used to visit the house of the accused. On the date of the incident, Sanjay Bhumis went to my house and told that his wife had slipped and fell down in his house and asked me to call the ambulance.
Mm.
I called the ambulance and went to the house of Sanjay Bhumis and saw Asha Bhumis on the bed in sleeping position with her face upwards. Asha
Liver
Bhumis-
ruptured,
Asha Bhumis was not in.
peritoneum. This is a case of the entire front portion being battered. Liver, abdomen,
Liver and-
peritoneum.
Lordship is reading the postmortem, my lord.
Yes,
41, my lord, page.
statement of the doctor,
Doctor,
PW1.
PW1, my lord.
Yes.
On 25/11, I was working at so-and-so. I conducted autopsy of the dead body of so-and-so at police location and submitted her postmortem in connection with so-and-so. The body was escorted by so-and-so. This is not relevant, my lord. Thin rigor mortis. Present. Bruise, multiple abrasion present over the cheek size 2 to 3 centimeters approximately. Cranium and spinal canal skulls healthy, membrane pale so-and-so. 8th, 9th and 10th ribs were fractured.
Mm.
Larynx and trachea pale, right lung so-and-so, lacerated injury present. Pericardium pale, heart empty, vessels healthy, abdomen, peritoneum full with blood, mouth, pharynx, esophagus healthy, stomach and its contents empty, small intestine, so-and-so.
Spleen, liver, both
Liver
ruptured.
ruptured, kidney ruptured, spleen ruptured. In my opinion, the person died due to hypovolemic shock following traumatic rupture.
Hypovolemic, not
Hypovolemic shock
hypovolemic.
following traumatic rupture of both liver and spleen, leading to massive abdominal bleedings, and it's antemortem in nature. Madam, kindly the cross-examination, madam.
Mm.
Except bruise and abscession on the cheeks, no other external injuries were found on the dead body of the deceased. These injuries can also be caused by sudden fall due to hemorrhage.
Mm.
There is least possibility and chance that the injuries sustained by the deceased in her liver could also be caused by falling on substance, but it is not impossible either. I did not mention the time of autopsy in any postmortem report. Now, if I take your lordships to the postmortem report at page 41, madam. Relevant part starts at page 42. Conditioned and number 2 is wounds, my lord, nothing. 3, bruise, position, size and nature. Multiple abrasion and bruise present over the cheeks. Mark of ligature of neck, dissection, etc. nil, my lord.
It's not a case of strangulation.
It's not a case of strangulation.
No one says-
It could be a case, my lord, of a fight between the two, my lord. Because the marks on the cheeks, my lord, he did not have any intention, my respectful submission, my lord, he did not have any intention to cause the death or to kill her, my lord, because he has 3 minor children.
Mm.
So it could be, my lord, that he pushed her or something, my lord, he fell down, the ribs could have been fractured, my lord. As a result, the liver and spleen could have been ruptured, my lord. That page 44 is the injury. And the subsequent conduct, my lord, after the incident, he went to the neighbor's place. He called them. Then they went, called the ambulance, my lord. He did not resist arrest, neither did he try to flee, my lord. So that,
Madam Public Prosecutor, why didn't you examine the first informant?
no, he was not informed.
He was not examined.
Why? That's such a shoddy state of affairs. He was the person who could have given evidence of motive. What was the motive for the accused to have murdered his wife? Tell us.
They had no, the relationship was not good.
Who said so?
Lordship witnesses, my lord. Lordship, because she used
Which
to reside in her
witness?
parental home.
Which witness? That is why we are asking.
The witnesses said that there were quarrels, my lord.
They used to have quarrels. She was in her mother's residence, my lord.
You have not examined the relevant witness who could have said so.
PW 5 says, my lord.
5.
in the middle portion, my lord. She
Mm.
went to her parents' house because of quarrel with her husband.
2-3 months prior to her death.
Yes, that is correct.
And she used to visit also, man. That is also there. in the
Lordship, all the witness, the 2-3 witnesses who are their neighbors, who went to her to see my lord, on being information given by the accused,
Mm.
they see blood oozing out from mouth, neck. Your
But
lordship,
please
and your
don't-
lordship, and there's autopsy inquest report, who says injury on the neck.
Don't
Yes, your
argue
lordship.
like a layman.
Page 46.
Madam, don't put forth arguments like a layperson. You push the evidence of inquest. Can it be read over and above the postmortem report?
Your lordship cannot, but your lordship, but the,
In that event, you are required to ask the doctor, show the photographs, inquest, ask the doctor to give a better report. Doctor doesn't say cause of death, strangulation, no injuries rather on the neck, larynx, trachea, all healthy.
but your lordship, the evidence given by the doctor, lordship cannot
What
be
was the
last word.
motive for him to murder his wife?
Because your lordship, there was,
Quarrels. Quarrels are
Quarrels
there in
seems to
every
be-
family.
but your lordship, general perception, a person falls down from bed, your lordship, there will not be injury on both the cheeks and
Assuming that he hit her with his fists and caused the injuries. There are no external injuries on this part. So it's not a case wherein he has used any weapon. Understand?
my lord,
So maybe he has used his fists,
my lord.
but then can he be attributed the motive and the knowledge? Both
No,
knowledge and the intention.
your lordship desires then the benefit, my lord, maybe under.
Benefit, that is what we are saying. That is the only thing which can be considered
Yes,
because his presence can't be disputed. my
yes.
lord.
Here
And
we
then-
see in 313, he and her wife, his wife.
He has
is-
made an effort to call the neighbors, call the
Yes,
ambulance.
my lord.
So that intention, guilty intention is
May not be there.
missing,
Right.
can't be inferred.
Right.
All right, arguments are, judgment is out.
Pass over matter, item 2.
None present even in the second round list after 4 weeks.
I'm appearing for secondary education.
Attendance part. Yes. Anything else? Done.
Keep here.
Thank you.
For orders, item 1.
It matters about.
My lord, this matter, my lord, initially, now today, my lord, IA application is before your lordship, my lord. There is 1 day delay in filing the review application, my lord. The review is against, my lord, order is page 9, my lord,
Order dated 19-4.
19-4. my
Hmm.
lord. My lord, here, my lord, after arguing at some length, my lord, by my senior counsel, my lord, that this, my lord, he prayed for withdrawal of this, my lord, appeal, my lord. Now, my lord, the management, my lord, the management wants that this matter to be, my lord, decided on merit, my lord.
That can't be your choice, sir.
No.
You have withdrawn it consciously.
My lord.
This can't be done.
My lord,
Absolutely.
Moreover, my lord, our, my lord.
Management has given you the authority to appear and
Yes, my lord. Now, my lord, only
Read.
on the ground that, my lord, I maybe, my lord, only on the ground that the concession given by the, my lord.
read the Vakalatnama, language of the Vakalatnama.
That's correct, my lord. Only two judgments, my lord, if lordship is, my lord,
Let's see the
pleased
judgment.
to, my lord, then. There's only a small one paragraph, my lord.
Yes.
First, the lordship 2015-7 SCC, my lord, 373 Himalayan Cooperative Housing Society, my lord, para 32, my lord. Last page, my lord. Generally, admissions of fact made by a council are binding upon their principles as long as they are unequivocal, where however doubts exist as to the purported admission, the court should be worried to accept such admission until unless the council of advocate authorized to authorized by his principal to make such admission. Furthermore, a client is not bound by a statement or admission which he or his lawyer was not authorized to make. A lawyer generally has no implied or apparent authority to make an admission or statement which would directly surrender or conclude the substantial legal rights of the client unless such an admission or statement is clearly a proper step in comprising the purpose for which the lawyer was employed.
It's very unfair, actually. It's very unfair.
My
After arguing the matter, then council craves liberty to withdraw,
lord.
and then because we gave out our opinion,
Yes.
he took a very conscious decision to withdraw it.
My lord.
Thereafter, now you turn around and say that we are not given instructions. What have you said? Let us see
My
in your application.
Yes.
Come to para two.
My lord. My lord, in the, my lord, the review petition, my lord,
Yes.
in the review petition. My lord, from
Para two. The opinion of the court was there. Thereafter, the decision was taken.
yes.
This is most unfair. Sorry.
My lord, in para, in page 7, my lord, para 4,
Mhm.
ground, my lord,
Mhm.
that is our my sole ground here, my lord. My lord, for the
Page 7 of what?
my lord, review application.
Review application ends at page 6. Page 7 is the affidavit.
Oh, I am taking up to this
We are having the first review, 1511. Read that.
1500, yes, my lord, this is my lord, I application, my lord, yes. My lord, for the delay ground, we have given a page, page 4, para 4, my lord.
Mm.
But the petition says the order dated 19/4/2020, a proposal was forwarded to the constituted committee, including finance member, to calculate the waste payable to workmen as per order 9/2/2020, 3% WPC number. So hence, the committee was constituted on 19/4/2023 and to submit a report on 25/4/2023. The regional office of the ONGC Nazira examined the report forwarded to the registered office of ONGC at New Delhi on 3/5/2020.
This was not a concession given. Judgment you are citing is of concession. It's not a concession. After hearing the opinion of the court, learned counsel says that, all right, we will comply with the order.
My lord.
So give us liberty to do that. Extension is sought. How it is a concession?
That's correct, my lord.
It is admitting to the, or rather agreeing with the observations of the court, all right, there is no merit. And let us withdraw and let us comply. It's not a concession. Or we'll give notice in your delay condonation, we'll hear that. Issue notice of the IAS seeking condonation of delay to the respondents. Rule steps for service be taken in 3 days. Rule is made returnable in 6 weeks.
I will.
Hmm.